Can turn them off. Yeah, well. Good morning. I'd like to call the December 17th, 2015 Planning Commission meeting to order, and the record show all the commissioners are here. I'd like for you to join me now with a salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. Any agenda changes today?
No agenda changes, just a note that we anticipate that the one item on the consent calendar will be requested to be pulled, so, but when it comes to that, we'll just pull it and discuss it at that time.
Okay. This is our public comment period. If anyone in the audience would like to address the Planning Commission on a land use issue that is not on our agenda today, now would be your opportunity. Okay, seeing no one, we're going to be moving to the consent agenda. So, Peter, if you could.
So, last meeting, we had the hearing on the appeal on the asphalt plant on the 035 determination. You've received a draft of the revised resolution that reflects the direction that we received from the commission last meeting. I know that a member of the public had indicated that they wish to pull it from the consent calendar, so maybe the best thing to do before we get into it is actually pull it off the consent calendar, and then we can get into the discussion of that.
So what procedure do we need to pull it from the consent?
I think just either ask any of the commissioners if they want to pull it, or the public.
Okay, any commissioners want to pull the resolution off of the consent calendar?
I have some suggested changes to it. I don't
Okay.
know if that makes a difference.
I
I have a
think-
question or two, so
So I think that would authorize
That
pulling it from the
qualifies.
consent
All right.
calendar.
So with that, as I mentioned, that the public hearing was closed. Our procedures allow for the public to comment on new information, so it's not there's not an opportunity to rehear the whole thing. The only point of discussion would be the new language of the resolution. Basically, the new parts of the resolution are the title of the resolution itself. On the bottom of page 2, the "be it therefore resolved" language was modified, and finding number 3, that finding and the evidence supporting that is new information. I know that Commissioner Wooster had a couple of changes, and maybe now would be appropriate to have those suggestions.
Okay, in the heading, it starts off, a resolution finding that the use of hazardous substances at the asphalt plant proposed to be operated at the Hogan Quarry will not have a significant effect, etc. I think the will not should be may not, to be consistent with 035. And the other two suggestions were on page 3, under number 3. On the evidence, if you go about halfway down, there's a sentence that starts, the evidence, including but not limited to the engineer's reports, suggests that the chances of an accidental release or mechanical mishap involving the asphalt plant that would result in a significant effect on the environment, and assuming project proponents' compliance with the myriad of applicable laws and regulations related to the project, is sufficiently remote to not trigger a finding of potentially significant impact under 17.42.035. I think the word suggest should be stronger. It should be shows. So it would read, the evidence, including but not limited to the engineer's reports, shows that the chances, etc. And then the phrase, is sufficiently remote to not trigger a finding, etc. Just a matter of grammar, that should be are, because it refers back up to the subject, which is the word chances, in the phrase chances of an accidental release.
where's the R?
It should be where it says...
Is sufficiently.
It should be are sufficiently remote.
Regulations, right, plural.
That's my only suggestions. I thought it was a good job.
Going back to Mr. Wooster's first comment about the will being changed to may, I'm not so sure, because yes, the ordinance reads may, and I think will not is the answer to may affect. If we say may not, may not, to me it indicates, well, it's a 50-50. It may not, but then again it may. If you say it will not, in our opinion, then I think that's the proper response to the 035 language. But I can understand the question, but I think this is the proper word to respond to the language of the ordinance. I can be convinced otherwise, but that's my take on it. On the top of page 2, the second whereas, a question, the need for the parenthetic statement. If it is referring to the fact that in the previous whereas at the top of the page, we determined that the language of 035 is not plain and unambiguous and therefore requires analysis, et cetera, et cetera. If it's responsive to that, I don't think that's a complete response to plain and unambiguous issues. There's interpretation that goes beyond whether or not it's is versus may. So I wondered why that was included.
I'm trying to go back to our thought process back in August, but I believe that these are two standalone findings or statements. Some of the questions that were raised previously in the decision tree that we walked our way through on that was, is it clear, is it ambiguous?
It does reflect our discussion,
yeah.
I recall that.
And I think that the discussion that we had on this was that we don't have to, in order to make the finding under 035 that there may be a significant impact, we wouldn't have to find that there definitely will be, or that there is a significant impact, that there is some question. And it gets to the issue of may, and I think it gets back to the point you made earlier, that the bar is fairly low to make the finding that there may be a significant impact. It's not an absolute, yes, definitely there is a significant impact, and I think that's what we're trying to say here. But in this case, you still were able to find that there wouldn't be a significant impact based on all the information and testimony that was provided last week.
Also, I think that was an argument made by the appellant that that you have to show that there is. And
right.
so I think that this is just directed to that argument.
That's absolutely right.
That's correct. There was a bit of an ambiguity in the ordinance.
Right.
Lastly, I don't recall seeing a resolution quite this long. I don't have a problem with it, but I'm wondering, I'm kind of an FYI, was it the intent of your department and legal to be more inclusive, almost like a minutes of the discussion for the benefit of the next level of consideration?
Well, we certainly want to document the basis for the action that was taken. There were a number of issues that were raised, as Fawn pointed out, by the appellant, and so this sort of states the rationale for each of those issues.
I think it's an accurate restatement of the condensation of the discussion. I think it's that, every bit of that.
Yeah. A 3.5-page resolution isn't out of the ordinary on a complex project like this.
Okay.
Complex decision.
Then the only issue remaining for me is the heading of the resolution itself. And I still favor will. I think that's the proper word. But it's up for discussion. I could be convinced otherwise.
That issue ties into the last paragraph on page 2, which is an important paragraph, where it says, "Be it therefore resolved that the Planning Commission grants the project proponent's appeal," goes on and on, says, "may not have a significant effect on the environment based on the following findings." So whatever we do here ought to be consistent. And the may, I think the may is clearly proper at the bottom of page 2.
I think Mr. Wooster makes a good point.
I can't provide any advice on that one. And maybe it'd be worthwhile hearing from the public.
Sure. Would you like to hear from the public now, before you make any decisions on that? So is there anyone in the public that would like to address comments on the resolution only? Specifically with the title, be that therefore resolved, findings number 3.
Joyce Tekel, myvalleysprings.com. Number 1, revised resolution 2015-019 is not supported with findings and evidence. The new resolution says, quote, "The use of hazardous substances at the asphalt plant proposed to be operated at the Hogan Quarry will not have a significant effect on the environment," closed quote. This statement is not supported by the findings and evidence. On page 3, under findings 3, evidence, it says the engineer's report concluded, quote, "not likely to be significant effects," and then says, quote, "chances of a release or mishap that would result in a significant effect is sufficiently remote to not trigger a finding of potentially significant impact," close quote, and continues, quote, "when the chance of a significant impact is as remote as the commission finds it to be under these facts," close quote. The words "not likely to be" and "remote chances that would result in significant impact" do not add up to the resolution's "will have, not have a significant effect." These chances remain the same as "may result in a significant effect." During the hearing, County Counsel Julie Moss Lewis said the appellant has the legal burden of proof to show that staff was incorrect and the burden of proof of proving that there is no potential for significant impacts. This proof has not been demonstrated in the finding and evidence with not likely or remote chance of significant effects. 2, the findings and evidence referenced also do not prove staff was incorrect. The text misquotes the Environmental Management Agency Director Jason Boetzer and leaves out most of his testimony. It says that EMA Director testified that he interpreted 035 as requiring him to find there, quote, "may be a significant effect if there is any potential, however remote, for an accident or mechanical mishap involving hazardous materials," close quote. That is not accurate and was not all the director said. When questioned about the remote possibility of releases and accidents, the director said, no, the possibility was not just from accidents, but from, quote, "normal operations," things that happen as part of operations. When accused by a commissioner of living in a closet in his interpretation of Code Section 035, the director responded, quote, "We have to look at every operation based on the method, type and quantity of materials, and type of operation. I've inspected asphalt plants before. I didn't live in a vacuum in Calaveras County, and seen some of the releases and just ongoing. It's part of the operations. It's looking at this, the ability to have a significant effect on the environment, even looking at compliance with all the rules and regulations. Hiccups occur in the operations, and there may be a significant effect. 3, staff provided substantial evidence to support a finding that the project may have a significant effect on the environment. Finding 3 states, quote, "There was no substantial evidence presented to the Planning Commission to support the health officer's determination that the type, method of use, and/or quantity of hazardous substances that will accompany the proposed change in use, such that there may be a significant effect on the environment." When commissioners asked what the word "may" meant, and if the standard was remote possibility of, the director responded that "may" meant the ability to have an effect, plus the quantity, type of material, and process. This ability to have an effect was clearly demonstrated in the director's staff report and testimony at the hearing. Finding 3 is in error. The statements we quote can be verified on the videos posted on the Calaveras CAP website. The revised finding, evidence, and resolution do not prove that staff was incorrect and do not prove there is no potential for significant impacts from the asphalt plant. Thank you.
Thank you. Sure. Hope you dropped your pen.
Oh, thank you. Good morning, Diane Kinderman with Abbott and Kinderman. I appreciate you reviewing the resolution. I understand the comments. I would concur with the existing language that says it will not have a significant impact. What the evidence showed last week was there may be an effect. Just because there may be an effect doesn't mean that it rises to the level of significance, and we believe that the evidence supports the finding that, in fact, there would not be a significant impact. Just because we say there will not be a significant impact doesn't mean that there couldn't be some sort of a minor effect. And we talked about that distinction quite a bit last week as well. So I believe that the language is appropriate. And as to the second page, the comment under the first paragraph of the evident, I would agree with the change that the evidence, including but not limited to the engineer's reports, show that the chances of an accidental release. I would agree with that change of the language. The word shows or illustrates or demonstrates would be fine. So I would request that the word will remain as county council wrote it, and that the change on the first paragraph of the evidence, that we concur with that change as well. Any questions?
Thank you.
Thank you.
Anyone else?
Janice Bassett from My Valley Springs. You know, this is so disheartening because it's so clearly important that we protect the residents that live right along that route and all the highway, the truck traffic. I mean, up to 150 loads of asphalt per day.
Janice, could you limit your comments to the comments on the resolution?
I just totally disagree with the resolution. I think that it definitely does have a significant impact on the environment. And I think that you should rule the way your staff recommended. Thank you.
Brock Estes from Valley Springs. So I'm here for two reasons. Your minds were made up before the last meeting. I have introduced the possibility that we might debate this. I would debate Commissioner Tono for 3 hours in front of the citizenry if we want to inform them. It doesn't appear he wishes to accept that.
Mr. Estes, could you limit your comments to the resolution?
Yeah.
Thank you.
The resolution is in part based upon the York report. The York report is fatally flawed. It's flawed because the information given to York Engineering was not correct. They were told there would be
Mr.
only
Estes,
2 more trips.
Again, could you limit your comments to the resolution before us, not to previous reports about the Ford report, but to the actual wording in the resolution? That's what we're entertaining comments on right now.
Okay, will there be an opportunity for further comment?
I'm sure at the Board of Supervisors there probably will be.
So not at this meeting.
No. Other than I would entertain comments on the resolution, the wording of the resolution.
And not how the resolution was formed?
No. No, just comments on the resolution itself. The title,
it's-
the be, therefore, it resolved section, and the finding number 3.
That's very unfortunate. Looks like I
I'm
made a
sorry.
trip for nothing. But doesn't appear to be a very democratic setup, does it?
Thank you. Any other comments? Okay, I'm going to close the hearing, bring it back to the commission for deliberation.
We're back on will or may. Will is a more definitive statement, definitive word in that setting. And I'm back to believing that that's the proper word to use. With respect to the rest of the resolution and reacting to public comment, it's not a full minutes of everything that was said by everybody, and nor, I'm sure, was it intended to be, nor could it be. With respect to the language that staff used to support its position, we voted that we didn't agree with the conclusions, regardless of the words that were chosen by staff to support its position. So that has to be understood, and it relates to the comments on the handout on the top of the second page, paragraph 3. I think that's it.
So is there consensus on Mr. Wooster's other comments about the show and the R
Oh,
on page 2 or whatever?
I
it was,
agree
page
with,
3?
I agree with
Okay, so
that.
the only thing that seems to be left out hanging is the may or the will. So maybe if we could have the commissioners just say, you know, what, each of us say if you want may or will, so that we can move ahead.
I'm actually comfortable with either one, because Ms. Kinder made a good point. The will goes to whether it has a significant, or will have a significant effect on the environment. And so while the ordinance uses the word may, this is probably supported by the evidence. I think it is. And so I think I'm okay with that.
As am I.
All right, I think I would support the may, but I think we've got a consensus on the will. So I guess, is there a motion to adopt this resolution 2015-019 as amended?
So moved.
Second.
It's moved and seconded. Any discussion? No? All right, all in favor, say aye.
Aye.
Opposed? Aye. So 4-1, motion carries. Thank you. So, moving on, we have our other public hearing, which is a continued discussion of the resource production element. Do you want to give us a little background, Peter, or?
Yes, so I think it was probably about a month ago that we first had a discussion on the resource production element. There were a number of changes that were made by the commission, some additional questions that were raised, and what we brought back to you are the edits that included changes you made, as well as further edits that I'm recommending based on the conversation we had at the commission, as well as additional public input. One of the questions that we weren't really sure about was the issue of prime agricultural land. We've done a little more research and really found that there are two uses of that term, both used by the Department of Conservation. One is a mapping exercise dealing with the actual soil type. The prime land that's been identified on maps that have been provided by the Department of Conservation to the county is a reflection of the use of land under the Williamson Act. And so while the terms are the same, the definition is different. And so the language that I'm proposing recognizes both uses of the word prime that we identify, prime farmland under the Williamson Act as those that are used for raising crops. But the actual mapping of the soil type county-wide has not been done, and so we don't know the full extent of prime farmland in the county from that perspective. So, and I've run this language past Kevin Wright, the Ag Commissioner, and he concurs with that language. And so that's reflected on page 2 of the next iteration of the resource production element. Some of the other changes that were made subsequent to the last meeting that, other than that, reflected by the action you guys had previously taken. On page 8, policy 2.8 was added. We had an implementation measure that discussed uses of solar energy generation on agricultural land, but there's no policy that was referencing. So that policy was added. Also on page 9, policy 4.4 we discussed a little bit about the water and the effect of mining operations on surface and groundwater, and so that policy was intended to address that issue. The solar use easements mitigation or implementation measure on page 13 was modified after discussing that further with the Ag Commission to have a better understanding of the laws that reflect that.
Which one on 13?
2C, top of the page.
2C.
Yes.
Okay.
And then I think the biggest issue that probably needs to be discussed today is Appendix B and the mitigation programs for loss of agricultural land.
Okay, can we back up, though, and stay on page 13 for a
Sure.
moment?
Yes.
RP 2E, Williamson Act implementation. I had suggested to you in an email that we consider an implementation measure to the effect that the county's requirements for Williamson Act status be reviewed with an eye toward the financial requirements of for that status, inasmuch as our discussions of Williamson Act recently have educated me on the fact that the financial requirements are based upon 1970 ag production dollars, whatever formula is used for that, and the whereas we are in 2015 and the ag numbers have changed considerably. So I think it warrants an implementation measure. Which policy it would be mated to, I'm not sure. But I think we need an implementation measure to the effect that the county should review its Williamson Act requirements to update the financial requirements from the previous 1970 levels. That was not a very good draft, verbal draft, but I think it's warranted, and I think we should be doing that. I think that should be kind of a front burner item for us, actually.
I think we could add, if that's really a policy question, whether or not we want to make entering into the Williamson Act more restrictive and increase the amount of income that's generated by the agricultural activity in order to qualify. And that's clearly a policy call. And we could certainly add language to 2E. It says update the county code relative to that, and we could add and financial requirements for entering into contracts at the end of that. So we update our standards, comprehensively throughout that, so it's consistent with state law as well as, any kind of changes that we think are appropriate.
Yeah, open-ended in that sense, but let me justify my position for a moment, then the commission and the public can weigh in. The Williamson Act certainly has as a goal to preserve ag land. But I believe it also is aimed at increasing ag production. And that makes sense. One of the examples that we had recently in the last Williamson Act application that we dealt with, which sent up the red flag to me, a landowner running 5 cows on 150 acres meets the financial requirement. Well, that's not very good ag production. So it shows that beef prices as they are, with 5 cows, you can meet the Williamson Act requirements of the 1970 financial dollar levels with only 5 cows. So that's not meeting, in my opinion, the other side of the benefit of the Williamson Act. It's a twofold benefit: preservation of the ag land, but also ag production. So it's this production side that I think we are, our numbers are obsolete in that regard. And I understand that this very issue was visited in past years, not that long ago. It was not advanced for one reason or another, but it was known to, it was believed, it was recognized as an issue years ago, and it should be even more so now. That's my rationale.
Well, I think the primary reason for the Williamson Act was to make the property tax burden commensurate with the ability of the land to produce, and to make it possible for people to continue in agriculture when otherwise the property taxes would force them to sell. That was the impetus for it. I have not understood that there was a production component to it. Maybe there was. But I have to say, if you have 5 cows on 160 acres, that's a cow to every 32 acres. You can run cattle in the mountains where you got a cow on every 80 acres for 3 months, and you're doing good. So you can only do so much to increase production, given the soils we have here and what you can do with it and the water. And if all the 160 acres will carry is 5 cows, I can understand that, if it has brush on it. But the alternative, which would make that property ineligible for a Williamson Act contract, may have some severe adverse effects. Like you may not be able to hang on to it. You may have to sell it and bust it up. But I'd like to hear from the public on this too.
And I agree with Mr. Wooster. I don't want to subvert the intent of the Williamson Act, but there must have been a reason for those production numbers to be there. And dollars change over years. So if you've got a dollar production component, and I don't know what the formula is that they used for dollar amounts, but there has to have been a formula, and to me it makes sense to look at the dollar amounts to see if they still make sense, to look at that formula and just update the dollar amounts. I think Mr. Wooster brings up a very good issue of some lands won't support an increase in dollar amounts, perhaps because of the topography, the growth on it, and that does that not relate back to the mapping issue and the scoring of land, if you will, based upon its potential? So possibly that, when you work that into the formula, and if it hasn't been already, then you get a variable of production requirement based upon the capability of the land. The bargain that the public gets from the Williamson Act is in exchange for the landowner getting his reduced taxes, which is very important to keep the land in ag production, the public gets ag production. To me, that's part of the trade-off.
Did you by any chance look at any other contracts in neighboring counties to see what their values were?
In neighboring counties, no, I don't know. I don't have that research.
I can tell you in El Dorado County that the return requirement is the same, $2,000, but there is an additional requirement that there has to be a certain amount of investment, physical improvements, either fencing or irrigation systems or something like that. I don't recall the exact amount that needed to be put in, but there was an additional requirement. So counties can modify those as long as they're no less than the minimum state requirements. So certainly, within the realm of, our authority to increase the requirements, as long as they are, no less than the minimum state standards.
Are we the minimum state standards?
Yes.
Okay. So
No, that's not true. We have a higher minimum acreage requirement than the state allows.
We meet the state minimum requirements. We increase the land requirement, but the state doesn't address, the state doesn't tell us what the dollar amounts should be. That's left to the counties, correct?
Well, the
Production.
standard is set by state law, which is $2,000. We can adopt a higher standard if we so choose.
So if whether the standard were developed in the 1970s of $2,000 is sort of, that's the state standards, that's their threshold.
Right.
So the state has not updated it.
That's correct.
In all of these decades. Other counties have, or to your knowledge?
Yes, other counties have adopted different standards, and they changed periodically. In El Dorado, just from my previous experience, there were a lot of small farms up in the Apple Hill area, 5 to 10 acre apple ranches that had plenty of income based on that specialty crop, but they did not meet the acreage size that the county had established back when in the 70s when the Williamson Act first became effective. And so, but the state did modify the land to allow for a high-intensity agricultural production, and the county then adopted standards that you could go into Williamson Act with property as low as 10 acres. But we had a higher income and higher investment requirement there than for say grazing operation. So counties can modify it again, just as long as you don't go below the, 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 the,
got some good farm people here. I see one of them
I'd like to hear from the public.
that I'm anxious to hear from. Hope he weighs in on this.
So, do you want to start from the beginning? And, I mean, we just jumped to page 13. Are there comments before that? Do you want us to go through these and then open for the public hearing? How would you like to proceed?
I'd like to have Peter finish going through the report, because there were he was going to go to the appendix, and we got off track.
Okay, so then the appendix worked with Kevin Wright and Bob Garamendi to make some changes to the draft that was prepared by the Ag Coalition back in 2011. One of the changes on page 2, the first page of the document, in the definition of agricultural conservation easement, there was actually some standard. So I took that out of the definition itself, the last sentence, and moved that over to page 4 under the methods of mitigation, number 1, since that's more of a development standard as opposed to a definition. There were some minor changes that were made, sort of based on concerns raised about exclusive use of conservation easements as a mitigation tool, and tried to make the language somewhat more general in nature. However, I think it's really important to point out that conservation easements are probably the most widely used and most effective tool for whether it's agricultural production or natural resource protection, a variety of different issues when land is taken out of one particular use to go to another one, and there's some mitigation that is required to address that. Conservation easements are probably the most successful and widely used tool that's around. And so it's hard to get away from that as an option for the county. Most of the other changes were just sort of clarification that to make the language a little more clear, and try not to sort of mix concepts within different sections. There weren't a lot of changes from what the Ag Coalition had put together. So just minor things here and there. And you can see that just sort of scattered throughout the document, where I just try to clarify some of the language, make it more functional, more implementable.
Thank you.
You're welcome.
So would you like to go through this? Were there comments prior to page 13?
Maybe the best way to do it would be to sort of finish up the language of the element itself, have the public weigh in on that, and then we can get into the, sort of break it up into two parts.
And to the appendix?
And then to the appendix?
Sure.
If that makes sense to you?
Sure.
Okay, I did have a question on page 8. The new RP 2.8 on solar energy installations. I'm not sure I'm real clear on what it means. Does it mean, in effect, solar energy installations shall be compatible with agricultural activities, and such facilities shall not be located on prime agricultural land and shall not reduce the production, etc.? Is that what it's really supposed to mean?
That was the intent, yes.
Then maybe we should say it that way.
Isn't that what it just said? What did you say? That's how I read it.
Well, the way I thought it was, what I thought it was meant to convey is the following. Solar energy installations shall be compatible with agricultural activities, and such facilities shall not be located on prime agricultural land and shall not reduce the production of the primary agricultural products. If that's what it's meant to mean, I think that's what it should say.
I'm fine with that.
Yes, I agree.
That's fine.
Actually, I had a comment on page 8. 1.6. It doesn't make, to me, a lot of sense that we've got Appendix B with a huge discussion about conservation.
Wait a minute, I'm sorry.
You
You're
mean
on-
2.6, or,
No, I mean 1.6.
Then you're
page
not on
6.
page 8,
I'm
right?
sorry, page 6.
okay, that's good.
Page 6, 1.6. So we have a lot of discussion about conservation easements throughout the entire document, the Appendix B, and yet we don't have a policy. We have implementation measures that support this policy, and yet we don't have a policy. It's like, I think we need to put this policy back in. Now, whether we include all of the, transfer of development rights, we've talked a lot about that, may not be applicable here, but I think it's important to have this policy back in here. I mean, there are conservation, there's discussion of forest conservation, mining conservation. We need
So
this,
it could be just use a wide variety of conservation tools to encourage the long-term productivity of resource production lands.
something.
Well, I think that there was one, because this was for general, I think that we took that out because we did have specific language in each of the sections under ag, under timber, and under mineral resources.
I think she's right. think
I
you're right.
thought what we tentatively thought we were going to do was leave RP 1.6 in, but delete all of the examples.
And that's, I'm good with that.
Yeah, I think you're right. I think
That
that's
is
right.
what we,
Okay. So use a wide variety of conservation tools to encourage long-term productivity of resource production lands. Right?
Yeah.
That's what I thought we were going to do.
Okay, I'm good there.
Okay. Thank you.
So I had another comment on page 9. And this is really a question on 4.4, the new one, mining activity shall not adversely impact water quality or availability of existing water users in the vicinity of proposed new. Should we also have or expansion of existing mines? I mean, could the expansion of an existing mine have an adverse impact on water quality or availability?
Certainly could.
Isn't it covered the way it is?
yeah,
Any mining activities?
It just says new mines. To me, that just is
I'm
applicable
lost. Where are
to
we at?
Page
4.4.
Page
Yeah.
9, 4.4.
I'm on page 9.
By definition, isn't, this means new mines, and what's the status of a mine when you've got a significant new use, significant added use? What's the language for that? Like the asphalt plant is a type of addition.
I'm not sure there is a term of art that's used, but I think that either vicinity of proposed mining activity, which would then include expansions. I mean, obviously, these policies would apply to discretionary activity or the drafting of new standards adopted by the county, and they would typically apply to, a new mine or expansions of the existing mine. I think you're talking about vesting, Supervisor Turno or Commissioner Turno? The vesting status of a mine. If it's vested, then we wouldn't really have any say over how it's operated.
If they're doing an expansion.
But if they're expanding it, and...
Then it's called a change of use.
Oh, okay.
But that's really a different definition, isn't it? I mean, if they've got an existing mine and they dig more than they dug before, that's not a change of use.
No, and it's really not technically considered an expansion either, because by definition, you're going to keep digging.
Right, you have
So-
to expand, otherwise.
Yeah, and the courts have ruled that that is not an expansion of the mine, the continued operation, which means, moving out either deeper or wider is not an expansion of the mining operation. And mining operations, you know, sort of ebb and flow as well. They could be idle for a number of years, and then they reactivate because the market is back up for that mineral, whatever it might be. And so there's a great deal of deference to, you know, the operation, as long as, you know, they meet the standards for reclamation and all the other requirements of state law. But if someone were, you know, significantly proposing, you know, an area that wasn't ever considered part of the mining operation, they wanted to expand out there, or we had an abandoned mine they wanted to reopen, you know, and there's difference between an abandoned mine and an idle mine, or, you know, a totally new mine. So
even if in just the vicinity of mines, because to me this seems exclusionary to only proposed new mines.
Because they have vested rights.
How can we, the county can't impose requirements retroactively, so we're kind of stuck with that.
I'm not sure, we're kind of stuck with what?
We cannot go back to a mining operation and say, you know, we've got some new water regulations, and here they are.
No, I understand that, but let's say there is an expansion of existing mine which triggers a new use,
But-
right?
But it depends on what the expansion is. If the expansion is the normal course of business, mines have to expand, otherwise they stop, so that's not a new use. That's not an expansion under the definition that you're aiming at, where Mr. Maurer said that under the circumstances of an idle mine, still, that's not an expansion. It would have to be, if a mine was abandoned and then reopened, then they would have to qualify for whatever new regulations the county has imposed in the meantime.
So since we don't have a proposal in front of us regarding a new mine, an existing mine, an expansion, whatever, is there, would there be a problem with having a policy that's just a little more inclusive, that if it does indeed affect that particular mining operation, that is expanding, if it applies, it applies, if it doesn't, it doesn't?
I'm not sure the circumstances that, I'm not sure of the circumstances that you're outlining. You've
So
got-
if the new mining activity were to require some type of permit, then we would look at this policy, okay, how is it going to affect water? If it wasn't subject to some new permit, if it was just a matter of, you know, reactivation of existing operations, we wouldn't require any new mine, or a new conditional use permit or anything like that.
Okay, so this would be triggered if the operation required a new permit for,
Some change of use, some
change
new
of
activity.
use or new activity or significant expansion that was beyond what was previously authorized in some way.
Madam Chair, I don't see the word new in the latest version on page 9, 4.4.
It's after, at the very end, last three
Says
words.
proposed new mines.
well,
4.4 reads, mining activities shall not adversely impact water quality or availability of existing water users in the vicinity of proposed new mines.
So,
If we tie this to the necessity to get a permit, does that do what you want to do? Say something like mining activities that require a new conditional use permit or a conditional use permit, et cetera?
I don't know. That seems to be more than what I'm looking for. I'm just saying, if there was a situation, as Peter outlined, that a mine requires a new permit, that it is not excluded because from an assessment of impact on water, because it's not a new mine, is because it's an expanding mine.
okay.
but if they were asking for a change of permit use, is that what you're looking for everybody else?
Something that would trigger them to have to seek, approve, or, would make them subject to an assessment of water quality.
Okay, and the question I have about that, the problem I have with it, and maybe the language could be found that addresses this, is, I'll use the example of a homeowner. A homeowner gets a permit to do something to his house, put on a porch, put on a carport. Okay, so he's changing his building. If our building department said, well, if you're going to have, in order to get this permit for this change, you've got to bring your house up to code in some other respect. that is really not affected by the, really not pursuant to the new addition, but it would be like that kind of a, in the extreme, it would be like that kind of a requirement, which the county doesn't do, and for good reason. There's a, I think the county probably has some other provisions, like if your house is more than 50% destroyed by fire and you got to rebuild it, then you'd have to, the electrical and the plumbing has to be, 2015 code, not 1970. So there's a degree of rebuilding that's required before the applicant is subject to all of the new codes. So how do you make this language reflect that kind of practice where, I don't know if it was a mining operation that decides, well, we need some on-site power here, we're going to put in a generator. Do they need a permit for that? And does that permit then require them to meet all the other new codes that have been imposed in the meantime?
Perhaps we'll wait and get some testimony on this one, it's out like the other one, from the public.
Yeah, I think change.
That's my only concern. You understand that?
Sort of.
It's the degree of change for triggering this that would be of concern to me.
Okay, so maybe we'll just leave it hanging out there for a little bit, if that's all right with you? Okay. All right. Other comments?
Well, there will be a lot on page 12, which is the Appendix B in the conservation easement situation. I would suggest we not tackle that at the moment, that we should finish up this mining issue and also the Williamson Act issue.
So maybe stop at
Page 11.
10, page 10? Stop before we get to implementation measures? Is that what you have in mind? So that's a clean subject change?
No, he has got comments on page 12, and that's part of the policies.
Yeah, you had raised an issue on page 13, the Williamson Act economic.
Yes.
So
I would think maybe we ought to tackle that.
go through page 10 and then we can tackle these. What do you think?
I'm really lost. What is it you,
Okay.
We're at page 13, but go to page 10.
Well,
Kelly, you had comments on what that you wanted to,
All I'm suggesting is that we not tackle the conservation easement and Appendix B situation.
we're going to hold
No.
Appendix B
Okay,
till later, but could we get through the implementation?
that's fine.
Okay, all right, so, you said you had comments on page 12?
That's the Appendix B in the conservation easement situation.
Well, do you have
RP1E
specific
and
comments on
RP1A.
page 12, though? Not the appendix?
They tie together.
Okay.
Yeah, there's the 1E, RP1E specifically references Appendix B. So maybe when we discuss Appendix B, we can also discuss that specific implementation measure.
Okay.
And RP1-1F
1E and 1F.
Okay.
deal with conservation easements, and I suggest that get lumped together with Appendix B.
Okay.
so we're just skipping over that one part. Fine.
All right, then other comments on the implementation programs? Measures? Anything else prior to Appendix B?
Page RP 17. The first bullet point, this is under mining reclamation, where it reads, mimic the natural undisturbed condition of land when creating or restoring plant or wildlife habitats and aesthetically blend the reclaimed site into the surrounding area. And I think we discussed this before. Where, what do you do when you have a big open pit mine like down by Copperopolis? And you have a big pit and you have a big hill. Reading this, it seems to suggest you have to push the hill back into the pit, which can't really be done.
thought we deleted that.
We
I
could
thought
say
there
we're
was going to be
practical or
changed.
something like that, and we could modify that language if, I mean, I think that to the degree that land can be reclaimed for some other use, we would want to try to do that, but you're right, there are certain circumstances where it's just not feasible or practical, and we can add language to that effect.
Would that work, for practical?
I guess kind of depends on how you feel about the word mimic and really how specific that is. I can read it to be just generally make it look like the surrounding area, not like what it was before you dug out all this material. That's how I would read it, but if somebody else, if it's possible to read it some other way, then somebody gets in a bind because they haven't met a standard. But
The intent is the former.
what does, I mean, we're dealing with SMARA, correct? And there are state regulations, specific regulations for that. Are we just repeating something that's in SMARA?
No, no. I mean, the county implements SMARA. The county has its own standards, but they're sort of similar to the Williamson Act. There are, some thresholds or a floor of, you can't go below this.
Right.
And
With respect to the reclamation, the aesthetics of the reclamation, what does SMARA say?
I don't know exactly.
That's an unfair question.
Yeah, it's, it needs to basically be so that it's, it's safe and that it's not causing,
They don't really go into the
they
aesthetic
don't go into the
qualities.
aesthetic quality. Yeah, it needs
Okay,
to
they leave that
basically
to
not
us.
have, runoff. It's reseeded,
Yeah.
it's vegetated in some way to prevent erosion.
When you write a reclamation plan, you state what you want it to be, not what it was. So in other words, you say, when we get through this reclamation, it's gonna be habitat for ducks, meaning you can have a pond. If there was no pond there before, that doesn't mean you can't do that. So you really put down what your intention is for a final use.
But in our county, that intention would be measured against this bullet point.
I just don't think it works. To me, the word mimic means it has to look the same as it did before, and I don't think that works. Mimic the natural, undisturbed condition of land.
When you pair mimic to undisturbed, you can certainly arrive at that conclusion.
I don't think this works. And I actually thought we had this discussion, there was going to be an effort to rewrite this to avoid that problem.
I don't remember, but
Yeah, we did.
I know we talked about this specific policy, and it may have missed the direction on that one.
You could say something like, when creating or restoring plant or wildlife habitats, aesthetically blend the reclaimed site into the surrounding area so far as practicable to do so.
I was going to suggest something along those lines, that might, satisfy I think that the blending, the blending is sort of what we want to see, rather than just sort of a industrial cut fill, that if it's going to be, we want it to sort of look more natural.
right. I think Mr. Wooster proposed some pretty good language.
Can you repeat that?
They always ask me
When,
this.
starts with when.
When creating or restoring plant or wildlife habitats, comma, aesthetically blend the reclaimed site into the surrounding area so far as reasonably practicable.
Okay, so we're basically striking the first phrase. And then what was the word that you inserted after habitats? Or the,
I just said, strike the word "and," just put a comma after habitats,
oh, okay. And then blend becomes the,
and then aesthetically blend, et cetera, end up with the phrase, "so far as reasonably practicable."
I can support that. I think that's,
That gets the intent.
Sure.
I believe.
Any other comments before we ask the public? No? All right, so is there anyone that would like to address the Planning Commission on the resource production element? And particularly helping us with those few areas that we're looking for some advice.
Bob Garamini with the Ag Coalition. I'll go back to the discussion on the Williamson Act. Kelly's correct insofar as least cattle and range operations that it varies tremendously what the carrying capacity of land is. Kevin Wright's not here today, but the Ag Commissioner has a Ag Advisory Committee that generally addresses issues that you're raising, and I don't see a problem with asking for a review of those standards. I know every county has a little different standard, and you're correct in that several years ago when Mary Mutz was the Ag Commissioner, there was an attempt to update those, and it, like you said, it stopped for whatever reason.
can you tell me what the impetus was for it several years ago, if you recall?
There seems to be a constant problem, if you will, or questions that come up as to the administration or the rules around the Williamson Act. Some specifically ranches being broken up where there's one Williamson Act and a number of different landowners and how you can administer those. It's always evolving. There's new problems being created by the splitting up of land, basically. And I don't know specifically at that time what precipitated that reform or that attempt, but there was a draft resolution created at that time, and that's as far as it got. I would suggest if you have language, maybe to review, and then. But I know that Kevin Wright and his Ag Advisory Committee deals with those issues.
If we included language that says we're going to review this, doesn't mean that the review has to stop with financial numbers. It can be all kinds of other provisions that the Ag Coalition thinks would be of benefit.
Well, I know part of it is something that Mr. Maurer mentioned. It's the county has quite a bit of discretion. And it's how the county hadn't addressed these smaller operations that we're seeing, some of these vineyards, and maybe they're 10-acre or 20-acre parcels with a 15-acre vineyard that wouldn't qualify under the county's old rules.
So we take a look at this other county and see what they did, and then maybe that works.
I think those items were addressed in the previous attempt as special. I forget the terms that were used, but anyway, those are the types of things that, as the county changes, as ag production changes, the county's experiencing, I think you and I had that discussion, that a lot of people are moving in on 20 or 40 acres and they want to be ag. And
Sure.
They want to do ag operations of some sort. So it's a matter of do those fit into that the Williamson Act program, and if so, how?
So there would be a benefit in looking at those aspects of the Williamson Act too.
I think it's always a good idea to
Revisit.
review things every now and then, yes.
So it would be my hope that the language that I'm suggesting would include, put everything on the table.
Well, I'm going to have to leave that up to the person who administers it, who would be Kevin Wright and his committee, how they, I'm just saying that they're there, and these are the types of things that they would be charged to do.
Sure.
If it's directed to do so.
I think it is absence, we can still slug in the provision that we will review our Williamson Act requirements, period. And determine the ultimate list of issues when we bring it back up and start the review.
The other point I want to make is on the last, actually, I'm confused too. It appears that there's about 3 different drafts, and it seems we're skipping maybe from one to the other or that, and while a lot of the discussion was going on, I was trying to find the right draft. And so I plead sort of like I wasn't paying full attention, but I did catch the part on the reclamation plan, and that's that 4I on page 17. A use permit and reclamation plan are required by the state on any mining operation over, I think, 1 acre or that moves X amount of tons. The specifics of a reclamation plan have to be tailored to the site and to the mining operation itself. To make some general statement in a plan like this, I think would be inappropriate and dangerous because, well, we went through the process ourselves. So when we submit a plan to the planning department, it's reviewed, it becomes before the planning commission and the board, and the reclamation plan is part of that. And I can't think of any operation that would be similar, whether it be a gravel operation or a different type of quarry operation. I'd be very careful about putting any kind of specific reclamation requirements in a general plan, because those are required by the state under SMERA, and each operation is different. And what you want at the end, you may just want, like the director said, address safety. You know, there's no way if you go out to, say, these quarries out here at the cement plant, where you know, mimic the natural environment. You aren't going to do that. You make them safe. You bench them so they need, you know, there's regulations for that.
The point that Ted brought up, that a rehab effort could be the creation of a duck pond wetland where there wasn't one before. Now, that could be a really good idea, but it wouldn't fit even the more general language that Mr. Wooster suggested, because it wouldn't have this blending effect.
I just think any time you have specifics like that language, it could be problematic down the road.
But it's really
Because-
between the operator and SMERA.
It's really not a restoration, it's creating something that wasn't there before that is consistent with the,
Well, there's reclamation plans that get approved that have actually, they don't do any restoration. You know, you have a quarry wall or something and you make it safe and that's the end of it.
because there's nothing more you can do to it. You can't cover it with dirt.
Well, you talk about a vertical or almost vertical quarry wall or something. And I just say this from experience, that I'm aware that what the process is and what you have to go through, and those reclamation plans are specific to that mining operation, and they have to come before the Planning Commission and the Board of Supervisors to get approval.
Most of our quarries were based on 33-foot benches. And if you're in hard rock, and you have a lot of those benches, other than in Canada, some of ours in Canada are different. And there's always some nut comes in and says, well, look what they did at Bouchard's Gardens. You know, you can't do that. You know, but some people aren't very realistic as far as what they think you should do in a reclamation plan. And that's why at the beginning you state what the final outcome is going to be. Whether it's going to be restored or if it's going to be a different kind of environment, different habitat, whatever.
So that's all I have. Thank you.
Thank you.
Morning, my name is Dave Haley. I'd like to caution the commission on not designating lands within community centers or redesignating them to resource production and adding the burdens that's being discussed today, mitigation measures, whatever they may be. It adds a tremendous economic burden to those who are trying to create economic development, and it's likely that it hinders those developments, specifically for those who have already applied or have applications pending or have a desire to develop. Community centers should be treated differently than the rest of the county. They don't impact much of the land within the county, but they're very important to the economic development. So I would recommend that you look at the differences and not redesignate lands within community center boundaries or proposed boundaries to resource production. Thank you.
Thank you.
Good morning. My name is Scott Thayer with Castle & Cook. I want to reiterate Dave Haley's comments. We're the property owners of a number of projects down in the Copperopolis area. Number one, Saddle Creek, and the number of projects that we've started with the county staff's team together a number of years ago. Got held up by the general plan process. And those properties, we had, intentions to process the entitlements, create maybe a different type of community than Saddle Creek, but again, a residential development. And again, we were going, hand in hand with county staff and moving forward. Got delayed in this process, and we would like to really continue that process and not have the zoning or the general plan on those properties degraded. Again, your support in this would be much appreciated, and have us start where we left off in terms of the three projects that we have: the vineyards, sawmill, and Copper Valley Ranch. Thank you.
Oh, excuse me, can you tell us where specifically?
I think you're talking about the land use map, aren't you?
Correct.
Yeah, and we're not
It's a map
addressing
issue,
that today.
not-
It's not for today.
Okay.
There wasn't policy language that sort of was a red flag to you? Or was there?
No, it's still our properties are showing up as
Preview of
resource.
mapping issues.
Right.
Okay.
Thank you.
Thank you.
Anyone else?
Tall person. Colleen Platt with My Valley Springs and the Calaveras Planning Coalition. Let me see. It's kind of a free-ranging back and forth discussion. I'm trying to follow where we went here. I just did want to thank the Planning Department and the Ag Commissioner for changing the prime lands mapping paragraph to more accurately reflect that we do have some prime lands in Calaveras County, and I think that should be reflected in there, and I thank you for doing that. And wanted to also make sure that RP 1.6 wasn't thrown out. I think that was an accident that it was erased, and it needs to be in there to justify the program. So yeah, we have to have that. So thank you for putting that back in. And let me see what else. We had trouble back in the audience here with this back and forth through all these pages, and we had different versions and different dates. So excuse me for getting confused here. On the Williamson Act discussion, I believe you're thinking about just leaving it as it is right now underneath there to update the county code relative to the ag preserves. Is that correct? Or
I think there may be further discussion
Maybe
about
further discussion.
recommending a review.
Okay, well, review and update to me is the same thing. So I was just going to say that, of course, reviewing and updating that section of the code would be excellent to do, but I would say that now is not the time to debate those issues. So that would be when it is updated. So it seems like it's a little off track to go where that needs to go right now. And then I can't remember what page that was. Let me see. Oh, there we go. Okay, so this is my page 11. I think it's your page different, but it's RP1E and RP1F. I think you're not going to be talking about that now. You're going to be talking about it when you're talking about the appendix?
We're
or
going
are-
to include those with the discussion of Appendix B, since they have to
Okay.
do with conservation.
Okay.
Yeah.
All right, so then if I want to talk about conservation easements, this is not the time to do that?
Probably not.
Okay.
I mean, where you will have an opportunity for that, though.
That's the direction I was looking for.
Yeah.
Thank you.
Okay. Thank you.
My name's Richard Blood. I was commenting on the water quality issues regarding the mines, whether it was new or existing. And there's two things in the statement, basically. There's water quality issues, and then there's the availability of water to the adjacent property owners. As far as water quality issues, if they have a mining operation, they're required to get waste discharge requirements from the Regional Water Quality Control Board. And they'll be sending in monthly reports, quarterly reports, depending on how often they report. Those are public documents that can be reviewed too. As in regards to the availability of water, so that if they, the mining operation, an existing one can impact people's groundwater. And that's kind of a policy issue, what the county wants to do. There's been lawsuits over this and other counties. The town of Volcano at one time, its water came out of a mining tunnel, and their water was cut off when a mining operation went in. So as far as what the county wants to do about that, it's maybe something you want to visit, but as far as the water quality issues, the regional board has authority. Okay, thanks.
Thank you very much. Anyone else? All right, I'm going to bring back to the commission for discussion, up into those two implementation measures and Appendix B, which we are reserving. So do we want to talk about the Williamson Act? Is there anything we want to add to that? What page was that? Thirteen.
13, RP2E.
Okay.
So I have three sort of outstanding issues. One is on page 9, the policy regarding water and mining.
Right.
Implementation measure 2E regarding Williamson Act, and
The mining mimicking the...
4I and the mining. Those are the three issues I see are outstanding. Is there anything else that we missed?
I know, I think that was the three.
I'm sorry, 4I?
Having
4I on page 17,
Right?
2E.
2E on page 13, and 4.4 on page 9.
So perhaps we should take them in order and do the mining one on page 9 first.
And there's actually 4, right?
Was there a fourth one?
So I have 4.4 on page 9. Page 12 was the 1E and 1F.
Which we haven't really got to yet.
No.
No, later.
We're reserving those.
Then
So
2E. And then you have 4I, and then what, okay, so 4I, I'm sorry, it's a bullet under 4I that I
Yes.
was looking at. I apologize.
No problem.
So, mining activity shall not adversely impact water quality or availability of existing water users in the vicinity.
How about in the vicinity of discretionary mining activity?
Say that again?
In the vicinity of discretionary mining activity. So when we have discretion over it, we'll look at these issues.
No?
I think I heard that the water quality issue is handled by the state anyways. And so I don't see why we would want to be having a policy as to that of our own. The availability of existing water users that's a completely different issue, as has been pointed out. So we may want to address that.
I guess my question would be, is the state water, or regional water quality control board, I mean, I guess that they would be monitoring or reviewing water quality through the same standards in terms of domestic use that the county would? I don't know.
Well,
I mean, are they going to be looking at the same issues that we would?
Are we proposing that our standards be more stringent than that of the, that of the state?
No, I'm not saying more stringent. I'm just asking, are we looking at the same types of water quality features that they are? I don't know. I don't know what they're monitoring for.
So it's true that, the mining operators have to report on all manner of things, including water to the state.
Sure, Richard, why don't you come back up?
As far as what...
Could you, I'm sorry, Richard Blood.
Okay.
I'll
Richard-
do it for you.
Richard Lutz?
Blood.
Blood, B-L-O-O-D. Okay. In a mining operation, the regional board will look at what they're planning to do for the mine. If it's a hard rock mine, and let's say they'll check for what runs off from the mine. They'll also maybe require them to put in monitoring wells to monitor the levels of water that's in the ground, also the quality. Though it's not uncommon where you're in a mining operation and they'll drill and they'll put in test wells and monitor the groundwater that's naturally there. And because it is an area where there is a mine, that, let's say they're mining gold, they'll find arsenic, chromium, and other things that are over the standards for drinking water. So when they do this water quality monitoring, it really kind of just, like Bob Garamendi was saying, really, the things are specific for the site. What they're going to be mining, how they're going to be mining, and then if they're going to process the ore there. So if they process the ore there, and then maybe they'll have special requirements, where they'll have groundwater monitoring where the waste pile is from where they process their ore. So it's extensive, and it really kind of depends on the monitoring or on the mining operation itself. But typically, they don't want them to degrade the groundwater. So if there is groundwater there, and it's, let's say, it meets drinking water standards, and so they'll have a monitor the groundwater so that if their mining operation, let's say, releases more arsenic or makes more arsenic available in the water, so that it, now is affecting the groundwater away from the mining operation, then, they'll be responsible. They'll have to, they set these discharge requirements, and if they violate it, then they can, stop their mining operations, fine them, there's any number of things that they can do.
Well, is the state doesn't just react to problems. I mean, they anticipate problems, do they not? And impose requirements based upon anticipated problems.
Oh, yeah, anytime anybody proposes to discharge waste to land or to the water, they need a permit from the regional board. Now, some things they waive and have the counties do, for example, for septic systems. That really comes under the regional board's authority, but they say that we'll let the locals take care of this because it's a small enough thing. But generally, anything other than that, they have authority. And so anybody who proposes to discharge, and that's just, you have any kind of an operation, and if you're not hooked to the sewer, you're going to have to get discharge requirements from the regional board. And if it's a mine, a landfill, or whatever, or even the timbering operations, that's part of the regional board reviews those harvest plans. So they're the state agency that's there responsible to overlook or protect the groundwater and surface water resources for all its beneficial uses for the people of the state of California.
So the purpose of a policy like this would not necessarily be to duplicate the state requirements, but when we have a mining application in front of us, one of the findings we need to make is it consistent with the general plan. And so we'd look at this policy and say, gee, the information we have from the Regional Water Quality Control Board, the information provided to the county by the applicant demonstrates that they won't have an adverse impact on water quality or water availability. Yes, it's consistent with the general plan. So it provides us sort of the backup information, or sort of the backstop for saying, well, how does the county address mining? And it's essentially saying we support mining as long as it doesn't adversely affect its neighbors. And this is sort of the parameter that's set for us to make that finding. So it's not intended to require additional or more information than the state requires. It's for us to work with the state, and then they can then say, yes, this is going to have an adverse effect, or no, it won't have an adverse effect. It gives us then the information and the tool to make the finding for consistency, or not make the finding, depending on the case.
Are you saying that without some kind of language to this effect, the applicant who would otherwise has to comply with state standards would not necessarily attach that aspect of his application to the county, wouldn't be in the file?
No, we would still do that. We would still do that. The only thing that, this is essentially a policy statement. It's the policy of the county that we support mining activities, but we want to make sure that that activity doesn't affect water supply and water quality.
Well, as to water quality, do you envision a situation where an applicant meets all of the state requirements that have been outlined, but your department would say, no, that's not enough, we're going to deny you your permit because we don't think that you've demonstrated sufficient protection for water quality to our standards?
I do not see that happening, mainly because we don't have that kind of expertise in the planning department. There may be a situation where you have different experts with different findings. And when we come to the hearing, then, we might have, member of the public or, some organization said, well, here's the data that we have on it. And then you or the board would have to weigh that and say, okay, well, here's, one set of data, here's another set of data, which one, similar to what we just did with the asphalt plan. And what's the finding the county needs to make in order to approve it? It's not big. We don't issue the permit from the state. We would have to analyze that in whatever kind of environmental document and come up with a resolution that, yes, it's it satisfies, or there's not a significant environmental effect based on the mining activity on water. I think that this is not really a critical policy. It's not something that's adding anything. It's just, again, it's a statement of the county's policy that we support mining, but we want to make sure that it doesn't affect its neighbors.
I think it's also important to not, that the water quality part of this is not sort of, I don't know if enforceable sounds like a harsh term, but it's really the water availability part of this policy that is addressed in the implementation measure, which is 4G. So there isn't an implementation measure for water quality.
So we can strike the water quality aspect of it.
Right. I mean, we're really talking about the availability of water with the implementation measure that quality isn't addressed there. So I would be all right with striking the quality part.
Well, I think we should, because it seems to me it doesn't serve any purpose.
I agree it doesn't serve any purpose. If we want to tailor it to water supply, that's different wording. If we want to tailor it to the county's policy of encouraging and, mining operations to make full use of our valuable resources, then that's a different kind of statement as well. And I don't have any problem with that.
So maybe if we just...
But it sounds like this has the potential of becoming is another 035. Maybe that's an extreme statement, but that's the sense that I get. It becomes another 035 kind of an issue with respect to mines.
I would say not, because the 035 is something where we are deferring a decision on the type of permit to an individual. We would have to look at this through the discretionary permit process, and this gives us guidance as to what we're looking for when an application comes before us. It doesn't set some kind of threshold of standard.
The bottom line is that this is specific to water quality. The applicant has to meet water quality standards of the state. We are not increasing those water quality standards in any way. And whatever component of the applicant's application that addresses water quality that is copied to the state is in the packet of information that our county would have on the operation. There's no difference there. It's not like they get to hide it from us. So I'm in agreement that this, as it's written, doesn't serve a purpose.
Right, so if we removed the reference to the water quality and just stuck it to the availability.
I think the availability needs to be in there, because when you go to the water impacts from mining operations, you're specifically addressing the potential impacts on people that are around there and their water sources as well.
So if we revised your suggestion, Peter, how would that read, taking out the quality aspect?
Mining activities shall not adversely impact the availability of water for existing users in the vicinity of discretionary mining activity.
Sounds good.
Does that work? Yeah?
Good here.
Okay, all right. Good. Moving on. So we are skipping over the ones on 12 because we're getting back to those. So back to the Williamson Act. Just update the county code relative, do we need more than that to, in the general plan, to ask the Ag Commissioner to review Williamson Act guidelines?
Yeah, I didn't draft a sentence on this one for your consideration. It would take me a minute, but I could do that. Or if you have one that reflects what we were talking about, I'm good. I'd hear it. Did I hear you just start in on a kind of a
No, I'm
suggested
just,
language?
no, I didn't. No, I was just asking what, in addition to what is currently existing in the text, that just, update the county code relative to agricultural preserves and call upon a review by the Ag Commissioner?
I don't have an issue with the way that it's written, because it's basically just saying we need to look at it, update it for consistency. I mean, I think that pretty much covers it.
Not quite. It doesn't.
I think when you're looking at the impacts of the financial, and if $2,000 is the state, you are looking at damaging people that are in smaller areas, and we are saying we want to encourage the agricultural. Why would you want to raise that dollar amount that would discourage people, even if they're smaller plots of land?
You're jumping ahead.
Yeah, I think
I
that's
haven't said that the dollar amount needs to go up. I said that the dollar amount needs to be looked at.
Well, and the entire guidelines need to be looked at.
Along with everything else.
Right, so if we just, have you got something, Peter?
Well, I was thinking that the sort of limited to consistency with state Williamson Act, I think requirements should be in there. But it doesn't say what the county needs. So maybe
County
we just
is the
wanna
issue,
say,
not the state.
For consistency with county needs and state Williamson Act requirements. And include the rest of it. So that we look at, one of the biggest issues we've had recently with the Williamson Act is that the state stopped providing subventions over the years, and that's had a significant adverse or economic impact on the county.
They stopped adding what?
The subventions were, so the tax break that the property owners are getting, the state used to reimburse the county for that difference. Back in 2008 or 9, the state stopped doing that.
So the burden.
So the burden is now fully on the county. And I think it'd be worthwhile for the county to look at that and say, okay, there are definitely benefits to the agricultural economy to have the Williamson Act, to protect those lands, to, to continue to encourage the production of agricultural resources.
That's a very good example of the trade-off that I was talking about.
And so I
Now
think
the
if we just
trade-off
put
is
in
even
county
worse.
needs,
Right.
that has, and we can look at that, and we can say, it's still a worthwhile program for us to,
Sure.
and we don't want to make any changes, but it just, let's take a look at it. And
County needs wraps that up.
Yeah. So I think if we just insert that after the with, and the rest of it is fine.
County needs and state.
Williamson Act, and I would also add the word requirements after act.
Okay, how's that read again then?
Update the county code relative to agricultural preserves for consistency with county needs and state Williamson Act requirements, and include provisions for open space and recreational use contracts. That's actually part of the state law, is why that's in there.
That's good.
I'm good with that.
Okay.
Great.
All right, then the last one was the mining.
I would also add the ag department as part of the responsible entity on that.
I've
Yeah,
seen that.
good.
Yeah.
We're back to the condition of the mine when it's no longer being used.
I have some language that,
Page what?
17.
17.
that I think is responsive to the discussion that we had, and this is, for the record, RP4I, the first bullet point. Reclamation plans shall be site-specific and, where practicable, will include provisions to either blend the site into the surrounding terrain or offer an acceptable alternative, period.
I think my preference would be just to delete it. It sounds to me like this is something the state takes care of. You do your reclamation plan up front. It's tailored to the project. We've been advised that every one of these sites is different, and it would be wise not to try to come up with some general statement to deal with them. So my vote is, or my inclination is to just delete it.
I'm all for deleting things that are duplicative of what the state controls, requires and controls. based upon the information today, you're saying that this is covered by state requirements? Maybe, well, I'm not sure I heard that.
I think this is basically a statement of the county's policy that we want to go beyond the minimum requirements of the state and restoration where it's practical, that would in some way, blend the reclamation plan with a more natural, that's what this the prior suggested language that Commissioner Wooster had, basically said that we want it to look more natural, not just meet the minimum standards of the state, where practical. In some cases, as Commissioner Allred had pointed out, you've got, benches into hard rock. You can't do that. It's just not practical. But there's some areas where you might have, say, a gravel operation along a riverbed where you're not really going that deep. When that's all, ended up, it may be ponds, but it's not just going to be like a, industrial site, type of, pond, replanting with vegetation, recontouring it so it looks more natural. That's sort of that's what that policy is trying to get at.
Okay, it seems that the state, through SMARA, has deliberately left this component of mining operations to the locale.
Yes, yes.
And
It's
so it's
delegated that
appropriate for
authority
us to address it.
Yes.
And I think this address, my suggested language, addresses it in a way that's consistent with our goal of being flexible. This is, what's practicable. It's an either-or situation, and it gives the applicant a way to offer something that suits us and is practical at the same time, and it's site-specific, so there's lots of different possibilities, all the way down to something very minimal. Maybe it's too vague. It could be criticized for being too vague, but I think that component, I think the county should address the component of reclamation in as much as the state doesn't go that far. Where they do in water, I see they do in water, but not in this way.
Yeah. Up to the rest of the commission.
What was your suggestion again? Could you
Well,
read it again?
You want to hear that again?
I would like to.
Okay. Reclamation plans shall be site-specific and, where practicable, will include provisions to either blend the site into the surrounding terrain or offer an acceptable alternative.
That kind of goes back to the guy that writes the reclamation plan, though. I mean, that's all included in when he writes a reclamation plan and submits it to the state. All that's covered as to what the ultimate goal is for that piece of property.
If he writes that to the state, then hasn't he written a plan that goes beyond the state requirement, according to what Mr. Maurer has just told us? The state requires him to do something, but it doesn't address aesthetics. If he says, and by the by, here's my aesthetic component.
And it's really not the state that approves it, it's the county that approves it. The county, the authority under SMAR is delegated to the county, and the county approves it, and the only time the state would get involved would be if the reclamation plan is challenged as to not meeting the minimum state requirements.
So could it be that if you've got a reclamation plan submitted and the county goes back and says, well, you need to, you can't just walk away, you need to restore that land in some way, that the mining operator could say, well, no, I don't have to do that. SMARA doesn't say I have to do that, that this policy would support the county's call for some remediation of the site?
Above and beyond the minimum
Yes.
standards, yes.
This would only be for new projects, it's not going back.
Right.
Correct.
And what was the edit that we had that prior, not Commissioner Tuno's?
Commissioner Wooster's previous
Maybe that was it.
recommendation before the hearing?
Yeah.
It was when creating or restoring plant or wildlife habitat, aesthetically blend the reclaimed site into the surrounding area as far as reasonably practical.
I think I prefer that one. And I think it
That
is
one
important to have it in here.
And the only real difference between Mr. Wooster's and mine is that mine mentions site-specific. Of course, they're all site-specific in that sense. But mine gives the applicant the alternative of offering something other than a blend to the existing terrain. It gives them, hey, how about this idea? And
I don't think it excludes a blend to the existing terrain. So I don't think,
Or,
I don't think.
Excludes an alternative.
I'm saying it's either or. You could do a blend, or you could say, county, how about this idea? How about the Mr. Alured's duck pond?
So what if we added a suitable alternative to that?
You could take the same idea and slug it into Mr. Wooster's
That's what I'm suggesting,
alternative.
yes.
Then it would read like this, see if I could do this on the fly. Aesthetically blend the reclaimed site into the surrounding area, or offer an acceptable alternative so far as either is reasonably practicable. I can read the whole thing again if you want.
I think.
You got it, didn't you, Peter?
Yes.
But it starts with the phrase, when creating or
Correct.
restoring, et cetera.
Yeah,
Correct.
I'm good with that. You guys?
Me as well.
Yeah?
Okay.
All right. All right, so, job well done. Shall we take a short break before we
Please.
come back and discuss the two last implementation measures and Appendix B? So, 11 o'clock? We will reconvene. We are going to reconvene our meeting, and our next topic of discussion is going to be Appendix B, and then the related to implementation measures, RP1E and RP1F. You had a few comments, Commissioner Wooster?
I had some questions to start off.
Okay, let's go.
The planning director. This Appendix B is a fairly complex document. Has this county ever had mitigation program guidelines as part of its general plan before?
Not that I'm aware of.
Okay, when a specific project comes up, is it correct to say that mitigation of some kind might or might not emerge as a requirement during the CEQA process?
Yes.
And so if there's mitigation required, and if so, what? Has that typically depended on the particular project, what it's doing?
Yes, usually if there's no sort of countywide program, then it's on a case-by-case basis.
Okay. Is there any requirement by the state that a county impose mitigation requirements or mitigation whenever land is proposed to be converted from resource production to another use, such as residential?
There are no specific requirements, but it is something that we are required to address through CEQA.
Now, if a developer comes up and decides to provide a complete EIR as opposed to a mitigated negative declaration,
Well, that would be the county's decision.
Let's assume that decision's made.
Okay.
To require a complete EIR, which identifies all the environmental risks. Can the county consider all those risks and say, we want this project to proceed, period, and not require any mitigation?
That's a difficult question to answer because of the vagueness of CEQA. CEQA requires that we mitigate to the degree feasible any reasonable mitigation measure, as long as it doesn't end up resulting in not letting the project go forward. So the mitigation measures can't be such that they, and I can't remember the exact term of art that's used under CEQA, but essentially that it doesn't stop the project, stop the intent of the project. So if the mitigation for a 500 unit subdivision is keep it all in some other use, well that sort of defeats the purpose of the mitigation. The purpose of the mitigation is to allow the project to go forward, but at the same time mitigate the impacts. So I got lost track there. We are required to mitigate where it's feasible. And at some point in time, if the county decides this isn't a feasible mitigation measure, then we need to state the reasons why and make the findings of overriding consideration. But we just can't say we don't want to do it because we don't think it's reasonable. You have to actually demonstrate why it's not a feasible mitigation. So an alternative might be, well, you could still have the same 100 units of density, but you could protect this wetland area or whatever it might be by clustering it. That would be a reasonable mitigation, by avoiding that area, still getting the benefits of the project from it.
Okay, if I understand that correctly, then CEQA is more than just a process document or a requirement or an informational requirement. It also has a substantive component to it, which
That's
is
correct, yes.
mitigate to the extent feasible.
Yes,
Somewhat different than the federal, as I understand
that's
it.
correct.
Okay, but is there there's no requirement that mitigation take the form of a conservation easement or an in lieu fee or any restriction on use of other land, is there?
There's no requirement that that be.
It's an alternative, but not a requirement.
That's correct.
All right. What advantage, if any, is there to adopting something like Appendix B as opposed to considering what mitigation ought to be required on a particular project as that project comes up?
The advantage of having an adopted mitigation program is that the applicant knows what to expect. And the county can have a program, a fairly simple process of saying, here's how we mitigate this. We've already sort of reviewed that and adopted it as our process. And in some cases, it's very easy to say, I can just pay a fee and satisfy that requirement if we adopt an in lieu fee program. Classic example is the Quimby Act for parkland mitigation. I'm not familiar with that because we really haven't had any subdivisions recently, but the state has set the ability for the county to either require dedication of parkland or require a fee in lieu of the dedication that can then be used to acquire parkland somewhere else for the benefit of that subdivision.
Can, or it's earmarked. Can be used, or it's earmarked.
It is
for that
earmarked.
use.
It must be used. Yeah, I'm sorry. And so rather than, and this is very often the case in, say, protection of oak woodlands or biological resources, where there's going to be incremental loss, and rather than having each individual project try to figure out what's the mitigation for my loss of 15 acres of whatever the resource might be, and figure out how to do that on site, or go negotiate individually with property owners to figure out I can do off-site mitigation here. There's a program in place. that says, here's how much you have to do, here's a fairly simple, straightforward way to mitigate through the process and get through the process quicker and easier. That's the benefit of having something like Appendix B. Now, Appendix B has not been fully vetted. We haven't had any hearings on it. That's why it's sort of an interim basis until we can get back into that and really look at it more closely. But this was something that was created by the Ag Coalition, had a lot of internal review before I came on, and was something that was recommended by them. And I thought, well, here's a great tool that we can use as an interim basis. Most likely, as we go through the EIR for the general plan, we will be looking at other similar types of mitigation programs. And the more detailed you can be up front, the better it is to support the environmental document as we get to the end of the process. So where we had this already, it seemed to be reasonably accepted by the agricultural community and others involved in that, and I don't know who else was involved in the drafting of that document. It seemed like a tool that we could use, and that's why I included it.
I have a number of comments on this. Shall I go ahead?
Sure.
Okay. As I read Appendix B, it not only encourages, it requires the use of conservation easements or an alternative mitigation method, including the purchase of banked mitigation credits, which are essentially units of conservation easements that are excess to whoever holds them needs. An alternative method can be authorized provided the lands will remain in resource production, consistent with these guidelines. Presumably that refers to the land that's identified for the mitigation. So, in one form or another, it's locking up other land. And there is the alternative of in lieu fees. But those are the use of those is limited to administering, monitoring, managing, or enforcing the mitigation method. So the developer pays a fee. It's kind of like a tax. It doesn't go to schools or sheriffs or anything. It goes strictly to more mitigation. So all of this really goes to locking up other land. It doesn't make any land better for resource productions. And all the reasons that I've given before why I don't think conservation easements are something this county ought to be promoting, as opposed to whether private people should be able to do them on their own, apply here. The big one being they are in perpetuity. And they short-circuit the process of figuring out what's the best land use for land when the issue comes up. The way Appendix B is written, any project that proposes to convert from resource production, general plan designation, to a non-resource designation is covered right up front. The entire acreage of the whole parcel that's subject to the general plan amendment is covered, not just the part that's going to be developed. On top of that, there is a 2-to-1 ratio. In other words, you have to obtain a conservation easement on other land at a ratio of 2-to-1 for the land that's being converted. If you're converting 1 acre out of resource production, you got to lock up 2 other acres. You know, other landowners might not want to have anything to do with these conservation easements. This might be a pretty difficult process, which takes you back to in lieu fees, which again, simply go to land trusts and similar organizations to further their purposes. So what this winds up being, really, is a huge tax on developers. They essentially pay 3 times for the development rights. Once for the land where they're going to do the project, and 2 times that for a conservation easement or in lieu fees. I don't think that's wise policy. And the end result is that when people go to, consumers, customers, go to buy into a project that's been subject to this, it costs a lot more money than it would have otherwise. And that money goes either to perpetuate more conservation easements someplace else, or in lieu fees to go to the folks that manage these things. That's why I'm not in favor of alternative B.
Are there any specific other comments? Because otherwise, maybe, I don't know if Mr. Garamendi would like to talk with us about the Ag Coalition. I mean, it might be appropriate now, you know, just to,
Yeah, I was going to suggest that it might be that the best thing to do would be to focus on the 2 implementation measures, 1E and 1F, as they, you know, and the general context of Commissioner Wooster's comments about whether or not conservation easements are appropriate to identify in the general plan, whether or not we should even have Appendix B as a part of the general plan. Then if it's the Commission's decision, yes, we do want this, and we do want B, then we can get into the details of B. You know, an alternative would be just to not adopt an interim standard at this point in time and defer that to the implementation. It's, you know, one more thing to add to the list of things we have to do without sort of an interim direction, but that's certainly within the purview of the Commission. So I think that the general concept of mitigation of ag resource production land mitigation should be addressed, and then if you decide that you do want to move forward, then we can get into the detailed language of Appendix B. Does that make sense?
sure. Commissioner Tuno.
Mr. Maurer suggested, maybe he's talking about RP1E. Language that does not reference Appendix B. Am I recalling that correctly?
Yes.
And how, can you give me a review of that?
Well, I would just, if Appendix B is too troublesome because it's too detailed, it hasn't been really vetted, we're getting sidetracked on this specific thing, we could just strike that second sentence. And just, it'll be more general that we will in the future establish something. That would probably be a good starting point, but rather than include that in the adoption of the general plan today, it is a future task as far as implementation.
Your suggestion is just consider the first sentence as...
That's an alternative you guys could consider if Appendix B is too troublesome to you. We will be required on any project that is going to be converting ag land or timber land or the resource production land to some other use to mitigate in some way. By CEQA.
Right.
So the purpose of this measure is to develop something along the lines of Appendix B so that there is a consistent mitigation program available for land developers. They know what they're getting into if they're going to be buying a ranch land and want to convert it to houses.
To the extent that concepts in Appendix D make it into the establishment of consistent mitigation standards will be the subject of that future debate.
Right.
I think that is the wise course of action, that we do not adopt Appendix B as the interim set of measures, but that it be considered as components thereof to whatever standards we come up with in implementing this measure.
Before,
It sounds reasonable.
sounds okay. Well, I like Appendix B for the reasons that Mr. Maurer stated, is that it does inform applicants about expectations. It does set a menu of options, I think, which is important and provides some consistency. I see it as a benefit for retention of resource production land. I think it's not mandatory. It provides property owners with options and tools. So maybe at this point we could, I ask.
Look at it this way, maybe, Ms. McLaughlin. Throughout the general plan elements that we've worked on, where when it comes to implementation measures, most often it's design something, consider something, develop, et cetera. That's the way implementation measures have been treated, so that those particular measures can get a full airing on their own at some future date. In this case, it's like if we're saying, well, here's this package where the measure has already been developed for you. It's a ready-made implementation measure. But we're not able, I don't think at this point, to take the time to fully vet it to see if whether or not this is what we want to live with for 20 years.
No, I think that's why they're called interim. And I think that they were developed through the hard work of a group of resource production people.
I agree that there's been a lot of hard work there, and that's fine. But where else do we have in our implementation measures the same kind of effect, where we say, hypothetically, develop a program that accomplishes thus and such, and in the interim, here's one that somebody wrote, and follow that one until you get your own.
So maybe this would be a good time to at least hear from Mr. Garamendi, representative, to see why he thinks it's important to have these interim measures in place.
Thank you. What you're debating right now is, first of all,
Bob, could you
Hi.
name for the record?
Bob Garamendi.
Thank you.
Ag Coalition.
Thank you.
If you're going to have mitigation measures or not. And it sounds like there is some interest in saying, yeah, we want to have mitigation measures, but take out the specifics of Appendix B. I think that's a step, a positive step, as far as recognizing you're going to develop mitigation measures. Kicking the can down the road, I can't say for certain how many years the can has been kicked down the road. It's easy to kick the can down the road. And that's why the Ag Coalition came forward, trying to make this process a little bit easier by presenting an interim plan. Of course, it's up to you. If you decide there's going to be mitigation for resource land conversion, that's good. If you're sincere about tackling the problem of what that mitigation is going to look like, that's good. What's being proposed is an interim plan. I know there's issues. Kelly obviously has problems with conservation easements. I personally see conservation easements as a property right. To deny it or discourage it from in a public policy, I think would be wrong. There's many landowners out there that feel if this is what they want to do with their land, they should have the right to do that. I know Kelly's argument is, how do they know what's going to happen in 50 or 100 years? Well, we don't. But that's a property right issue for the landowner. So I think there's, what I'm see here is there's a real question as to the use of conservation easements as a mitigation tool and the pluses and minuses of that. Unfortunately, it's really one of the only ones available today, or there are very few available. And that's impeding your ability to move forward with Appendix B. And obviously, it's up to you. I really don't feel like arguing the point much. I think you've read it. It's there in front of you. I talked to Mr. Haley years ago when we were developing this, and I think, and the director mentioned this as well, when developers come in, and I agree it's going to cost more, this type of mitigation, but they know going in what they need to do. There's none of this having to come before, year or months of hearings and that. They know that here's a plan. We can write a check for that, and we're done. Whether it be buying a conservation easement or an in lieu of fee or some other mitigation measures, which I think are out there in the future. But it sounds like you're willing to accept the idea of mitigation for the conversion of the property. And then the question is Appendix B. We feel it provides you an interim plan that can be amended. But I hate to see the conservation easement argument be the reason this is not adopted. I think that's again, I think it's a private property right issue, and if a person wants to sell those rights, he should have the right to do that, he or she. That's it. Thank you. And I'll answer any questions as far as any other thought we might have had in developing that.
Any questions, Bob? Maybe later. Thank you very much. So at this, should we invite the public to weigh in on this issue? Yeah? Sure. Okay. Anyone else would like to address Appendix B and mitigation?
Sure. Colleen Platt again. I agree with everything Bob had to say. The Calaveras Planning Coalition has been working with the Calaveras Agriculture Coalition for years and supporting their efforts to preserve resource production land. We're not always on the same page on things. As you know, we like to protect our open spaces, but we respect the private property rights of the agriculture resource production landowners to be able to choose their way of developing and protecting their lands. And the Ag Coalition has come up with what we consider a pretty reasonable program. Like I say, we don't agree with everything that they say, but this program looks real reasonable. They've worked on it for years, believe me. They've been working on this for years. And as it's been noted, and you've undoubtedly received my email detailing that conservation easements are the most effective way to preserve open space and resource production lands. There may be other options, fees and deed restrictions, but they're not as effective as conservation easements, and it is the option of property owners to do this. And it's a development tool I mean, we're normally not pro-development. I think you know that about us. We're for responsible development. This is a development tool, and we're supporting this. It's a tool for development. If it's part of this program, as Bob and Peter said, otherwise you have to go on every development project that comes in front of you on a case-by-case basis, wrangle, argue, go to months of hearings. Ted's been through this for years. We've been through it for years. It's painful on the communities. It's painful for the planning department. If you don't have a program up front that the developer knows what's expected, what he's going to have to do, then it takes months and months, and you're costing him money. So this is a way to facilitate that process and make it predictable. This has been done for our road mitigation. We used to have to do this for projects on a case-by-case basis to argue for road impacts. Now we have road mitigation programs that they pay fees. You're done. You move forward. This is what this is trying to do, is set up a program so that possible development knows what's expected, they can move forward. So again, it's a property rights thing, it's a flexibility thing for developers, it helps protect resource production, open space, productive lands, it benefits the public. It may cost the developer a little bit more, but the final product is a property that's worth more. You're raising the values of the land by doing this. If you allow them to develop, you've created properties that are valuable. This is bringing tax income to the county. Seems like a win-win-win on many different levels. So I'm not sure what I've not covered. I sent you a long, not too long, email this time talking about the advantages of conservation easements, and I hope you read that. And again, I agree with Bob Garamendi and the Ag Coalition and Peter's suggestion that an interim program is useful because it shows the county is serious about mitigating land conversion. And we can vet it later, but this at least gives us something to move forward through the general plan process. So I encourage you to both keep Appendix B and to keep the concept of conservation easements as a mitigation option in the program. Thank you.
Thank you.
Morning, Barney Crane. I totally agree with what's been said. I just wanted to add one thing. When Colleen mentioned that it might cost more, I think I see that differently. It may cost more upfront, but if they had to go months and months and hearing after hearing after hearing, their time is worth money, their developer staff time is worth money. It sucks the resources out of their development dollars. And so in the long run, not having this, I think, would cost them more money. That's all.
Thank you.
My name is Bob Dean. I'm a resident of Calaveras County and Vice President of the Motherlode Land Trust. And I don't think I could have said it any better than what Bob and Colleen said regarding conservation easements. They're a necessary and important tool for the future of Calaveras County. And I would like to state that some of the problems I know that people have had with the concept of in perpetuity is that, once it's done, it's done. But I would suggest to you that if the land is sold for development purposes, that's also in perpetuity. So this is a necessary and I think appropriate tool in the toolbox that we need moving forward for the future of Calaveras County. Our county is based on at least the current interest of people in Calaveras County is the fact that we're a rural area. We have open space. As I said in a recent op-ed, your view isn't necessarily the wall of your neighbor's house. And I think that it's important to realize that conservation easements, and I'll admit that there are certain limitations. It's an either-or process, which is unfortunate. There possibly could be developed, and I don't know if this will be a state or a county issue, an interim program perhaps where we're talking about conservation leases as opposed to easements, so that you can ease into this thing over a period of time. What the benefit might be, I don't know. but that would have to be something that's discussed. But I certainly would urge you to keep the conservation easement tool in the toolbox, so that as the county moves forward in dealing with the next iteration of growth, we have the opportunity to look at our options. If anybody has any questions, I'd be more than happy to answer them.
Thank you. Richard, would you like to come to the microphone? No, but you're going to have to come to the microphone if you want to speak. Even if you have a question, you need to get, come on, Muriel.
Good morning, Muriel Zeller, Valley Springs. I've submitted extensive written comments to you and on conservation easements and mitigation ordinances and programs, and I hope that you found that information useful. I agree with Bob, both Bobs, with Colleen. Conservation easements are not only an important tool, they're almost unavoidable in terms of mitigation, because any easement for mitigation purposes must be perpetual. So if you're going to mitigate, and also the project proponent cannot administer the mitigation land or the mitigation program. So you're going to have another entity that is able to administer any mitigation lands and enforce the restrictions. But mainly I want to point out that this Planning Commission has been very adamant about doing the minimum that state law requires in terms of the general plan and remaining flexible. I would like to point out that the resource production element is a discretionary element and is not mandatory. So if you want to do the minimum, you can throw the whole element out. The point of having the resource production element was to demonstrate the importance of resource production land in Calaveras County. And part of that element, a major part of that element, were the two appendixes, including Appendix B. So if you're going to throw out Appendix B, I think you're sending a message that you don't find resource production land to be all that important.
Thank you. You coming up, Richard?
Richard Blood, and I just have a question. I forget the number. I guess it's RP1. Anyway, there's in the document it mentions the mitigation measures and has some language there. Is that language going to stay, and then we're going to, in the current draft, or is that going to be changed, and then is the idea that they'd come up with interim measure, or the new Appendix B? I don't know, has the language changed that's in there?
Well, not yet.
Oh, okay.
I don't think, not yet. I think that's what we're deliberating right now.
Oh, okay, so
Yes.
there may be, okay, all right.
Yeah.
Well, I would say that the language stay the same and that Appendix B be used as an interim measure until such time that a draft, or, they could...
Permanent guidelines or...
Yes, through an open hearing process so everybody can put their 2 cents in.
Okay.
Thank you.
Thank you very much. Anyone else? All right, I'm going to close the public hearing, bring it back to the commission for deliberation, and I think the question on the table here is really the inclusion of Appendix B and the implementation measures as an interim guide until such permanent measures are adopted or guidelines.
All right, I'll start. it's been suggested that Appendix B provides an option. There's nothing optional about what that provides. It's conservation easements or its equivalent, period. Or you pay the in lieu fees, and as I said before, you pay for the development rights 3 times because of the 2 times figure. It's been suggested, well, this is just an interim measure. Well, sometimes these interim things have a habit of hanging on for a long time. And one can expect this one to do exactly the same thing. It's been suggested that we shouldn't deny or discourage people the private property right of entering into one of these. Nobody's doing that. People are perfectly free under state law to enter into conservation easements anytime they want. They can donate them, they can get paid for them, doesn't matter. What this does, it puts the county in the business of requiring these easements, and I don't think that's right. It's been suggested this needs to remain a tool in the toolbox. It is. It's in the state toolbox. People can open the state toolbox and use it anytime they want. Mitigation is going to be required under CEQA in some form. I think it's been established that it doesn't have to be in the form of tying up other land forever. And perhaps some thought to be given to mitigation measures that actually improve resource production rather than just lock up other people's property. That's my response.
I also wanted to emphasize that we're not taking away anybody's property rights by putting Appendix B on the shelf, that conservation easements, they are a property right. By the way, they're a property right granted with conditions. They're not, it's not universal. If they were universal, I would have them on my half acre. This Appendix B, in my view, might work as an interim plan if it were absent the controversial components and if it was just kind of a starting point. You're going to, county, you're going to develop a full plan later. Here are some starting points. That would be an interim measure. But this is not this is not written as an interim measure. This is written as a full-blown, very detailed document with controversial components to it that amount to, for consideration by this commission, or at least by me, the study equal to a major element in the general plan. It's not just a little add-on. It's loaded with details that need to be vetted. I understand they satisfy the people who wrote it and all the work that was done, but I couldn't, sitting here today, evaluate all the components of this and all the ramifications. I just couldn't do it. So I would be in favor instead of the tactic we had previously discussed, where RP1E concludes after the first sentence, giving us time to consider what a full plan should be. And if you want to call that kicking the can down the road, I'm sorry, but it's not ripe for decision. That's it from me.
I read Appendix B the same way. You've got one choice or another. It is not an option. And I'm more for sticking with the mitigation conversions to encourage them. encouraging private organizations and land trusts, I'm good with that, but I think that when I read B, I struggled with it because it didn't provide options. It was, these are your two choices, pick one. So I'm also falling in line with these two.
When I read mitigation B, I was completely confused, I must admit, because it seems like it's almost a thing that's in here like, these are the rules, okay, now here's what you can do to get around the rules. And I'm not sure that's particularly good. So I'm not really turned on by anything in B, personally.
Well, I'm actually thankful for all of the work that the Ad Coalition went through to prepare this mitigation plan for the conversion of resource production lands. Interim or not, I think it's an excellent start. It does send a message that this county is concerned about and cares about the protection of resource production lands. I do think it is a tool in the toolbox, and that it does provide flexibility. As far as the perpetuity issue, I agree. I mean, it's you put a shopping mall on a piece of land, and that's going to be there a long, long time. So I mean, I'm in support of keeping Appendix B, keeping Appendix B in. For all of those, for all of those reasons, as well as I mentioned before, that Peter Maurer had talked about, it does inform applicants about expectations. It does, when you're looking at CEQA, provide a kind of a standard guideline for identifying mitigation that's consistent. So for those reasons, I think it does, it's not mandatory, it does provide property owners with some more flexibility and tools. So, but I'm in the minority here. So I guess the alternative, like looking at RP1E, it sounds like eliminating the last sentence may be resolution to the issue of Appendix B. So just taking out reference to it. Does that work? Kelly, you're...
Well, I think that should be done. I'm looking at the first sentence. And what I'm wondering is whether, like, with consistent mitigation standards, that implies that there is a one-size-going-to-fit-all when one of these CEQA issues comes up. If and when anybody undertakes to develop anything in this county, again. I'm a little troubled by that. I suppose it might be a good thing if we had some mitigation standards that would be available as alternatives, as opposed to an effort to set up a bunch of requirements in advance that people would have to comply with no matter what the project was or where it was, because the way these things are set up is you're talking about the conversion of resource production land to non-resource production uses, and that happens right up front when somebody tries to get his property out of RP, land designation. Very first step. And that may be a bit ambitious.
I agree with Mr. Wooster that the word consistent does require a one-size-fits-all, and that's a dangerous road to go down. Whereas if the language read, establish mitigation standard alternatives for the conversion of resource production land to other non-resource production uses, period, would solve that problem. And it makes a lot more sense to be flexible through the use of alternatives that on a case-by-case basis, one alternative or another is more appropriate for the issue at hand. To try to model them all around one formula is dangerous, impractical, inflexible, not a good idea.
I'm looking at 1D, and I'm not seeing, I didn't bring appendix, but it's also referencing the appendix A here, and it references the significance for the land conversions. If we wipe out that second portion of E, how's that going to affect the language in D?
It doesn't.
Okay.
That's the evaluation step, and this is the mitigation
Right.
step.
Exactly.
Okay.
Commissioner Tuna, could you read your suggested language again? Establish mitigation alternatives?
Okay, so first sentence, first and only sentence, establish mitigation standard alternatives for the conversion of resource production land to other non-resource production uses. Let's see, standard is plural or singular?
Standard alternatives, you said.
Yeah. Actually, you don't need the
Becomes
word
an adjective.
standard at all. Mitigation alternatives. Agreed?
That's better.
Yeah. Establish mitigation alternatives for, et cetera.
Do you need the word other?
No.
I guess that's really not
Redundant.
necessary either. If it's non-research, it is by definition other.
I think that would be correct.
That does it for me.
Are there any comments on 1F?
I have a comment. And that's the fact that the county here would be encouraging the use of conservation easements. It's one thing for the county to encourage the conservation of open space by various means, and the landowners are free to do that, but I don't think the county should be guiding that process or encouraging one method over another, or any particular method. The use of conservation easements are going to come up, or they're not going to come up according to the desires of the property owner. And I just don't think the county should inject itself into that process.
I agree with that. Along those lines, Calaveras Enterprise reported Supervisor Kearney is saying, what the county looks like in 10 years might be anything that crosses through my mind right now. And that had to do when they were approving what we had done on the vision statement and the guiding principles. His point was things need to be flexible. And if anything, conservation easements are not flexible. You're not talking about 10 years out, you're talking in perpetuity out. And so I don't think this county needs to be in the business of encouraging that particular method.
Other, Lisa? 1F? Ted?
No comment at the moment.
I'm still thinking about that.
All right, shall we open it to the public to comment on, are you guys ready for that, on 1E and 1F? So is there anyone in the audience who would like to talk about these two, discussion on resource production 1E or 1F?
Bob Garamendi, Ag Coalition. I'd ask Kelly, and I'd ask the commission, if today a proponent to a development operation came in saying, I'm going to mitigate this operation by purchasing a conservation easement on this land over here, how would you feel about that?
Well, I think that could be done. My problem with Appendix B is it's required. But if a developer came in and said, I have a willing landowner that wishes to grant me a conservation easement, and that's what I propose to do for mitigation, I think the county could do that, clearly.
Would you as a commissioner be in favor of that?
Might depend on the circumstances, really.
That's all.
Thank you. Anyone else?
Gee, I'd like to have answered that question, too.
You can go ahead and answer it. Commissioner, go ahead. No? Did you change your mind? You're thinking.
Oh, no, I was just sort of babbling. I didn't want to interrupt Muriel.
I had a question for the
Muriel,
commission.
could you say-
Muriel
Thank
Zeller,
you.
Valley Springs. And that was, what other type of mitigation is the commission proposing for the conversion of resource production land to non-resource production land uses?
Thank you. I don't think we're proposing any.
What we are proposing with the suggested language is that lists of alternatives, lists of tools, lists of alternatives would be established. And they would include set-asides, parks, setbacks, and the like. I'm sure there's a longer list than that. But that would be developed in compliance with RP1E. But I would also, I want to kind of answer Bob's question, if I may. The developer who comes in and says, I've got this project, and I've got a landowner, and we've got the conservation easement that I want to do to mitigate. He could be overshooting the mark, but that's okay with that should be okay with us. If he wants to overshoot it, and he's a willing buyer of those rights, and he's got a willing seller, then my answer to your question would be, go for it. That's your business. That's different than the requirement to do so. Again, he could be overshooting the mark by a mile. I don't know. But if he wants to do that, that's his right to do it.
We were just trying to establish the mark, I guess.
But you understand my answer? It would be none of my business if he wants to do something greater than what I might otherwise suggest.
I think, you know, the value of conservation easements, they've been around for 50 years or something, a long time. Your statement is he might be overshooting the mark. Part of what we're proposed is trying to establish the mark. And I guess that's what you as the Planning Commission, if it happens within your tenure, will be doing here in the next couple of years, establishing that mark. And I can't really argue with the thought of sort of that scenario I laid out. Sure, you know, let the developer find, you know, if that's agreeable, do that. What we were told, the ag community was told, is that the development people want to know that the more they know what their requirements are going to be, the better it is for them. And that's one of the main purposes of coming forward with this, is that what you're doing now, you're saying, okay, we're going to have mitigation. And until you develop those standards or that, the criteria or whatever that might be, it's in limbo. You know, it's a shot in the dark, if you will. But we did not come up with that on our own. We went to the developers, and what they want is certainty. They don't want to have to, I forget which speaker said that, come here in public here. Well, you've seen it in your tenure here, the different, how long these things can go on. And that I just want you to know that. And when you we were trying to establish the mark and a means of getting there. And if you read Appendix B carefully, it mentions alternatives. And I would love to see alternatives developed. And I think what you're doing is that you'll be revisiting the issue later, and I guess we'll see what happens. But thank you.
Thank you.
I want to point out one more thing about 1F, and that is when you include conservation easements in that sentence, it's inconsistent with the noun modifier long-term. It's not long-term, it's permanent.
Mr. Dean, were you going to,
I wasn't, I don't think it finished. If you want to say.
well, who's ever next?
Comment on two words. One, consistency, and the other one, flexibility. When we're talking about consistency, I think we're talking about process. I don't think we're talking about one-size-fits-all standards. And that's just what Bob was talking about. When you come to propose a project and you don't have a level playing field or you have a moving target, you're not going to get any place. And so that's the importance of consistency. As far as flexibility is concerned, when we make decisions, we limit the options down the road. It's just part of life. If I choose to live in Calaveras County, that means I don't live anyplace else. I have limited my options and I have reduced my flexibility. But I made that choice. 10 years ago, most people in Calaveras County, as elsewhere, did not know about conservation easements. I kind of halfway think one of the reasons that the Ag Coalition put the concept of conservation easements in the proposals that they put for this resource production element is to make people aware of the fact that those were available. Now, perhaps if you want to change the wording a little bit, and unfortunately I don't have it in front of me and I can't speak to it, if you say something like mitigation measures such as conservation easements, you haven't eliminated the possibility of conservation easements, but you've also implied the fact that there are other things that may be available. And I think the important thing is for us to be able to have these options, to have all the tools in the toolbox. You know, if you buy a kid's bike today, when you look at the directions, we all know what a pain in the neck they are trying to put together. If they don't tell you the tools you're going to need, you're not going to be able to put that thing together, or you're going to spend an awful lot of time trying to find those tools. This is just one opportunity through the general plan process to define some of the tools that people may have as options. And as far as the issue of flexibility is concerned, again, that's a decision that's made by the individual property owner. They limit their options down the road as they put a conservation easement on that piece of property. But it's a choice they've made. And if we don't want to have to live with a conservation easement when we're looking to buy property, we go someplace else. Those are the options that we have. So I think it's important to make available, for the purposes of consistency, all of the possible options that people may have when they want to look at how they're going to make use of their property and how they want to live. And if we don't mention that as an opportunity and as an option, then I think we've done them a disservice. Thank you.
Thank you.
Colleen Platt, I don't want to be redundant, but I just want to agree with everything that keeps being said. We're talking about somebody who is trying to exercise an option to develop, and you are giving them options to develop. You're not making them do this. If they want to develop, that's their choice, and you're allowing them options to develop. As they keep saying, developers want certainty. We've been dealing with projects down in our area for over 10 years. They've been trying to move forward. They can't move forward. We don't have mitigation banks set up. We don't have a program set up. So they come forward and they say, "Oh, we can't do this because your county doesn't have something set up. You don't have mitigation banks. You don't have this set up." So every project is a battle. Every case by case is different. There is no level playing field. It depends on what developer has the most persistence and money to fight something for years and years and years. It shouldn't be that way. You should be setting up a level playing field for your developers. They want certainty. Thank you.
Thank you. Anyone else? All right, I'm going to close the public hearing, bring it back to the commission. I think we've covered the bases here.
It's true when people enter into a conservation easement, they limit their options down the road. And that of the people who succeed them, and the ones after that, and the ones after that, and the ones after that. I could go on in perpetuity, but I won't, because that's what these things do. And I haven't heard a developer come in here and say, I want to know for sure that this is what I have to do. Apparently, so far, we've been able to have developments in this county without anything like Appendix B or required conservation easements or anything of the sort. So I don't see a need for it now. If we're on 1F, I still don't think that we should be promoting the use of these by name.
So what if it just said encourage private organizations and land trusts in the utilization of conservation methods for long-term protection of resource production lands?
What would the county do to do that? I mean, how would the county go about doing this encouraging?
Well, by having some, standardized guidelines for resource production land conservation.
That's in 1E.
Yes, I know, but that's how they would do it. So we're just saying that we're supporting that.
Well, if that's all we would be
1E
doing...
says we're going to have it. 1F says that we're going to encourage and support people who also want to take advantage of it. That's the difference I see.
I still don't know what we would do to encourage this, other than what's already in 1E.
In listening to Bob Dean, it sounded to me that, and correct me if I'm wrong, just mentioning that these are options in our county was something that would satisfy you. You just didn't want to see it deleted from here completely, correct?
That's a fair submission.
Okay. So, I'm not sure it would make you happy, but making sure that people, because we've done that in other parts of the general element, where we make sure people are aware these are options in our county. It doesn't say that we have to, we don't have to establish it, we don't have to encourage it, but we could make a placeholder in there letting people know that that is an option for them in our county. I see you two leaning towards deleting it completely. Is that a correct statement?
Let me ask a question
No?
about that previous. Why private organizations and land trusts? Why are we encouraging them? Why do we target them in this particular?
Typically, they would be the holders of the easement. Okay. And I think to get to Mr. Wooster's question is, what would the county do to encourage? I'm not really sure what it would be other than to, and maybe we use the word coordinate with. So that if the, so Mr. Garamendi's suggestion of, someone coming in and says, I want to propose as my mitigation for the conversion of this land, a conservation easement. Well, who's going to hold that conservation easement? Who's going to be responsible for long term? The county doesn't have a system in place for accepting and maintaining and monitoring. So we're going to rely on some other agency or some other organization. So if it's a case of wildlife habitat, for example, then the State Department of Fish and Game might be the holder of that conservation easement. There isn't, to my knowledge, such an agency at the state level or local level that manages and monitors conservation easements. But a land trust or some other organization might have the wherewithal to do that. So that would be where the county would get involved with those kinds of organizations to
Then, would you...
to manage.
Would you agree that with the proposed change in 1E, that 1F minus conservation easements, if you will, but 1F reads more like one of the alternatives that we would come up with to meet our goals of 1E. For example, instead of encourage, make known to private organizations and land trusts conservation methods suitable for the long-term protection of resource production lands. So, one of the comments was people 10 years ago didn't know about conservation easements. And if they still don't know about conservation easements, and it's the county's desire to let people know about what can be done, then that would meet that goal. Make it known to them, make it known to landowners, organizations, etc. Here's a tool that you can use. So it reads, in my mind, the goal, the thrust of 1F reads more like an item on the list that we talked about coming up with to satisfy 1E.
If that's the intent of the policy direction you want to take, then that does that. I mean, I think if we sort of step back a moment and look at what is it we're trying to do with this resource production element. Is it just simply accommodate land development and mitigate to the minimum requirements of CEQA, the conversion of resource production land in the county to some other use, then then it's simply notification to people that these options are available. That's fine. If the policy direction of the county is we want to do something over and above that and take steps to protect and encourage the continued production of natural resources, I think that was the initial direction of this policy language. That
you wrote.
Right, and that's different than the language you guys are suggesting now. So, you guys are in the position of providing policy guidance to me and to some degree to the board when we look at what we're trying to accomplish with this resource production element.
How is what we're attempting, how are the suggestions we've just voiced inconsistent with the introduction to RP?
Well, we've just kind of eviscerated the whole thing, basically. We've said that we're going to protect resource production land, but then we're just going to keep it a secret about how we're going to do it. So we've just gutted it, basically, and if we're, it's like, I think we are just going right back to the minimum.
I think you're speaking in I think that's a bit of an exaggeration.
You might think so.
Well, I think when we started this process, we had the vision statement and the guiding principles. And the idea was that the open space and resource production would be maintained and managed by the people were in charge of that ground, and what the county was going to try to do was to enable them to do that job, rather than force edicts down their throat.
No,
and
but
say
you also
can't.
aren't giving them tools.
I'm not done yet.
Okay, I'm sorry.
And this resource production element does quite a bit to try to do that. The biggest single component, I think, is the Williamson Act. That is absolutely critical. The next one is the right to farm ordinance. And we have a number of other things in here that don't cram rules down people's throats,
Right.
but try to enable the people who are actually working this land to keep doing it. I don't think it's fair to say that we've gutted the entire effort at resource production by saying locking up land and conservation easements is not the end-all and be-all.
Or by saying that we are going to come up with alternative measures that people can employ without saying that we've got a suitable interim package right now.
So let's get back to resource production 1F. In or out? Let's just get a vote and move on. What's your pleasure?
Well, on 1E, I would suggest that we go with the language that Mr. Tuno came up with.
I think we've pretty much covered 1E. I think there was some concurrence. I'm moved on to 1F.
My inclination is simply delete 1F.
Okay.
I would say delete 1F, and when we are designing the alternatives for 1E, it should be part of that program. If there's a county educational program that's, would benefit landowners, then fine, let's give it to them.
Okay.
So 1E is establish mitigation alternatives for the conversion of resource production land.
No standards.
I
Establish-
took standards out, I'm sorry, that's
Right.
out. For the conversion of resource protection land to non-resource protection uses.
Right.
Correct.
And if you delete 1F, you're deleting the option that they would have for alternative conservation methods, right?
You're not, this was an encouragement component here. And there's some of us that don't like the idea of encouraging conservation easements. However, it was suggested that a lot of people simply don't know about them.
Right.
They are state law, they can be employed, and if it's important that organizations and property owners know about conservation easements, their pluses and their minuses and all of that, then making that known to the organizations and landowners as a conservation method, not for long-term protection, but for permanent protection, if that's a viable component to the standards, to the alternatives that we are going to come up with under 1E, then fine. It plugs in there. It's not an implementation measure in and of itself. There's a lot of words to describe that. Did you get that?
No.
Oh, okay.
So,
Personally, I think 1F, once you take out the reference to conservation easements, you might just get rid of it. I actually agree with Commissioner Tuno that, it does become sort of a way to implement 1E.
I like the word actually in that sentence. Right now, I'm looking at RP 1.6 to see what happens when if we delete 1F.
Actually, I think 1E more accurately implements 1.6. I was going to suggest we add that to the list of policies that provision is implementing.
So just move it up.
okay, so when we put that back in, such as conservation easements, long-term conservation leases, So we stopped back at,
Oh,
when we put 1.6 back in, where were we ending that sentence at? Use a wide variety of conservation tools such as conservation easements.
No, stop after tools and jump down to encourage the long-term productivity of resource production lands. So use a wide variety of conservation tools to encourage long-term productivity of resource production lands. We just dropped the list of what some of those tools might be.
So is this, I mean, well, at least I know that, well, we had 3 for getting rid of 1F. Would this be a good time just to summarize where were the changes? Or do we need to do that?
well, let me look at a housekeeping issue here. 1F purports to support policy 16. 16 having been deleted, or am I looking at the wrong?
No,
version?
16
that was not deleted.
It was
It showed-
erroneously deleted.
Yes.
Okay.
So
It was revised to just be the simple statement I just read.
1.6 will,
Oh, okay, then.
that will move up to
Then
1E.
simply 1E will support 16.
Right.
There it is. That's the answer.
So do we need to go through these changes, or is it fairly clear
That's up
about?
to-
I think it'd be good just to, I'll
So- do you have a
summarize
summary?
the changes that we've made
Okay, 'cause I
today.
think we've covered everything.
So 1.6 we're keeping, but it's a shortened version, eliminating all of the examples. We jumped to page 9, and that was revised to read, mining activities shall not adversely impact the availability of water for existing uses in the vicinity of discretionary mining activity. In the implementation, we've modified 1E to read, establish mitigation alternatives for the conversion of resource production land to non-resource production uses, and we're adding 1.6 as a policy that measure is implementing. I think, although I'm not sure, that 1F is being deleted.
I believe so.
Correct.
Yes.
And then on 13, RP2E reads, update the county code relative to ag preserve for consistency with county needs and state Williamson Act requirements, and include provisions for open space and recreational use contracts. And the ag department would also be part of the responsible entity. And then the last change was the second to last bullet on RP4I, page 17, and I think I have this right. When creating or restoring plant or wildlife habitats,
I'm sorry, back me up. Where are you?
Page 17.
the very last,
Got it, okay.
yeah, page 17, the mining one. When creating or restoring plant or wildlife habitats, aesthetically blend the reclaimed site into the surrounding area or provide
An acceptable alternative
an acceptable alternative
so far.
so far as it is reasonably practical.
Correct.
And those are, and we have deleted appendix B.
Right. So is there, we're making a motion, right? Are we doing?
Yeah, yeah.
So is there a motion to approve the resource production element as amended?
I make the motion to approve it as amended.
Second.
It's been moved and seconded. Any further discussion? All right, so all in favor, say aye.
Aye.
Opposed? So it passes 5-0. Thank you very much. Next is our public comment period. I don't know. Would it matter? Sure. Come on up.
You're the chair. You can decide.
Come on up, Bob.
Under our...
Wait till you get to the microphone, though.
Okay, Bob Garum, ND
Thank you.
Ag Coalition. Under RP2E Williamson Act implementation, you added some words, county needs.
Yes.
Can you explain that?
Well, there was a lot of discussion about the fact that the county can modify its standards as long as it doesn't sort of go below the floor of what the state requirements. And just as we review the standards, we should look at what the county needs are as well as just what the state minimum requirements are. So there was some discussion about whether or not the dollar amount should be increased. Maybe it should, maybe it shouldn't, but rather than get into a policy discussion of that right now, we just make sure that we're looking at, the county's benefit of participating in the Williamson Act, and are there any changes we need to do to our standards to ensure that the county continues to benefit from that?
Including acreage?
Yeah.
The term county needs just seems
Very
like
broad.
Well, I don't think it says what you just said. That's you've already asked.
All right. Anyone else?
If that's a concern, we could revisit it. You could move to reopen this issue. The meeting's still going on, so.
I think it's okay.
I think it's all right.
Okay.
It says.
Are we in final
I don't think it can.
public comments, or is it attached to another issue?
No. This is final public comments.
Oh, okay. Bill McManus, Calaveras Project. You guys are probably as up to date or more so than I am on the inner workings of government. What we've got going on now is kind of a rush to get some ordinances prepared in advance of the March 1st deadline for the new marijuana laws that go into effect January 1st, commonly referred to as AB 266. AB 266 was passed almost 3 months ago. In the last 3 months, I can sense that nothing has been done. We're not moving towards an ordinance. I could be mistaken. I have been working with county council, and what I've gotten so far is kind of the PowerPoint that was used last April when the Board of Supervisors chose to do nothing, and we ended up in the situation that we were this past year. So there's, I believe on Tuesday, County Council will be discussing getting direction from the Board of Supervisors on how to move forward. And based on that, it will go back to County Council for formulation of ordinances, which supposedly are coming to the Planning Commission. Now, in looking at the PowerPoint of the two questions raised at the beginning are whether there's going to be indoor growing or not, or outdoor growing or not. And then further into the PowerPoint, there's a slide, Q3, that's alternatives. Well, to my way of thinking, the alternatives should kind of be at the beginning. Do you want indoor growing? Yes or no. Outdoor growing? Yes or no. Or alternatives. Now, last week I gave you a draft proposal of an ordinance that I had been working on because I didn't sense that anyone else was. That was kind of a greatest hits ordinance from 3 different counties and 4 cities who have banned marijuana. And one of the alternatives on Q3, which will come at the end of the presentation, is banning cultivation until state provides its own regulatory scheme. This seems to be antiquated language. So it's, if this is what you want to do, go ahead and do it. If not, you better ban it, because if you don't, on March 1st, the state will take over the operation of all marijuana activities in Calaveras County. And there's some very specific things you have to do to avoid that. So it's not that I'm pressing you guys to do anything today. I just want to make sure that we're all on the same page, that the Board of Supervisors is going to be giving direction to County Council. Ordinances will be, draft ordinances will be developed, and then it will come to the Planning Commission. At this point, there is no way I can get alternatives in front of the Board of Supervisors. That will come at the Planning Commission level.
And so what I'm asking of the Planning Commission is that you give alternatives that don't come from a government agency, i.e. county council, some consideration that maybe that would be a good alternative. So that's, I've given you my draft ordinance. I don't know if you've had a chance to read it or not, but that was vetted out among many agencies and counties and cities and municipalities throughout the state, even to the point that every single appellate ruling or Supreme Court ruling that has been issued against a city or a county was looked at in that ordinance, and the corrective language was inserted to try to make the draft ordinance that I put before you as bulletproof as possible. So as far as I'm concerned, there is nothing in that draft ordinance that need be feared. It's just a matter of getting a hearing on it, and I hope that the Planning Commission will give it a fair hearing before you send your recommendation back to the board for final adoption. I fear it's not going to be done in time. The board has to have the final ordinances adopted by January 29th, because the adopted ordinance has to sit for 30 days before it becomes active. The deadline is at the end of February. Fortunately, it's a leap year. You have until February 29th. On March 1st, the state takes over. So I don't know if you can get that much work done, given that there's holidays, Christmas, New Year's in between. That pretty much means you've got about 3.5 weeks in January to get all this done. I know, I'm finished, but I appreciate your attention.
Thank you very much.
Anyway, if I can answer any questions now or later, be more than happy to. Thank you.
Anyone else? All right. Any reports?
Just wanted to, well, yes, on Tuesday, the board will be having a study session giving direction to staff, county council, myself, other staff members involved in the crafting of whatever medical marijuana ordinance we'll be working on.
That wasn't already done?
No. No, we had a workshop in April, as Mr. McManus just pointed out, and the board decided not to adopt any new ordinance. And now with the state regulations, and we've been working on, on coming up with, what are the options and everything for some time. The first we could get it on the board's agenda was the 22nd.
To your knowledge, legal and your department, you're not waiting to get the directions. You are coming up with alternatives in
We'll be looking at the
advance
full
of
range
that.
of alternatives, including a complete ban. That's certainly within the range of alternatives. But it's probably premature to be talking too much about that right now. It's not on our agenda, but I just want to let you know that that is, the board will be giving us direction on Tuesday, we hope, and then we'll be moving forward from that.
What day is this?
Next Tuesday. 22nd. This is our last commission meeting of the year. We've been working really hard over the last couple of months. I hope to have the conservation and open space element before you next. And my question to you is, do you want to meet on the first Thursday of the month on the 7th of January to do that? Or do you want to continue with the special hearings on the general plan? Do you want to try to fit them into our regular agenda? I don't know what we have scheduled for the 14th, which would be our first regularly scheduled meeting. I'm pretty sure I can have the conservation easement or conservation element available for you before the end of the year, so that you'll have time to read that for the 7th.
Well, that's
Well, that's what I'm asking. Do you want to do it the 7th, or do you want to
7th or
just?
the
You say you're probably not done with it yet, but you're
I'm
confident
working
you
on
will
it
be.
now. I should have it done before the end of the year.
The 7th may not, I may be gone the 7th.
7th's the holiday, right?
I think I may be out of state on that weekend, that week as well.
So why don't we just say the 14th?
14th, okay.
Yeah, does that
That
work?
gives me a little more flexibility
Yeah.
time-wise to
Yeah.
work on other things like marijuana ordinances.
Right, so it'll be January 14th.
January 14th,
And
okay.
conservation open space. Yes. All right, anything else?
I will probably remember something as soon as we close, but no.
All right, well then we're adjourned, and happy holidays and Merry Christmas to you all.
Two.
Yeah.